Appearances.
Good morning, Your Honor. The State of Wisconsin appears by Special Prosecutor Robert Jamboys, Deputy District Attorney Carly McNeil, and Public Service Special Prosecutor Beverly Jamboys.
Attorneys Bridget Krause, Jeremy Perry, and Mackenzie Renner appear on behalf of Mr. Mark Jensen, who appears in person. Good morning, Judge.
Good morning. All right, the record should reflect the jury is not in a courtroom. We have some housekeeping matters to take care of. The first one, the clerk has provided the attorneys in the court with the exhibit list. Is there any objection to the list as it is prepared now from the state?
Not from the defense.
There's no objection from the state, Your Honor.
Is there any objection from the defense?
No.
All right, can I have the attorneys then sign the original? If one of the bailiffs could take the copy to each counsel. Switch it, I'm sorry. The clerk has the original. I forgot about that. She's the boss. Switch it. Ones that were not offered or not received.
Correct. Your Honor, the state would offer Exhibit 90 into evidence if it was. I thought it had been, but Exhibit 90 is the comparison contrast suicide homicide by Dr. Mainland.
All right, that'll be received.
I mean, Judge, I'd object to that. I mean, it's being offered. We're not in front of the jury.
Bailiff has to move so I can see the lawyers.
Sorry, I would object to that. It wasn't offered. The evidence is closed. We're not in front of a jury right now. All those reasons, but I mean, it was described. It was certainly described by Dr. Mainland, but it was never offered.
Bailiff has to move so I can see the lawyers. Thank you.
Well, Your Honor, first of all, I thought it had been offered into evidence, and we can ask, and I see the court reporters nodding her head. So it was offered into evidence. It just isn't recorded here, but we did offer it into evidence. We did move it into evidence.
Let me look at my notes. I think Mr. Jamboys is right, because I marked down every exhibit that was offered and received. And I've got a notation that the study was offered, so it is going to be received. So that's the only addition, Jan, is 90. All right, so we got that taken care of. The next thing is the instructions that have been provided to the court. I'll ask who's going to talk for the defense as to the instructions?
I will, Judge.
All right, thank you. Have you had a chance to review the document that was prepared by the state?
Judge, I have, and outside of just a misspelling, I have no issues with the instructions. The only thing I was wondering is if we wanted to do an instruction about the legal arguments outside the juror's presence, because we did have them leave a lot, and there is a simple instruction we could give if the court felt it was appropriate.
What's the state's position as to that?
I don't really think it's necessary. I think we kind of explained it to them as they were excused. So.
You mean when we would ask them to leave?
Right.
Yeah, I think we've explained it to them numerous times. I told them that obviously we had to do some legal issues, and I think they understand.
Other than that request, Judge, I'm fine with the instructions.
Right.
On page 8 under video recordings, actually it's fine. Everything is right. I just reread it.
So there's no objection to me reading these instructions?
Correct. Not from the defense.
Okay. So for the record, we reviewed the opening instructions and all the other instructions that are attached. I will indicate to the attorneys, I will read the instructions before their closing arguments, but I will stop on page 13, and then when the closing arguments are done by the lawyers, I will read page 14, 15, and 16, and then we will swear in the bailiffs after the verdict comes in and we are done with the case. I will read page 17. All right? Any objection to that from either side?
No, Your Honor.
Okay. Now, have the attorneys had a chance to, I should also ask the defense, to two verdict forms. Any objection to the two verdict forms?
No.
All right. Have the attorneys had a chance to look at the issue of the alternate jurors? And I did read the case that Mr. Jamboyce talked about yesterday. It's kind of the defense has all the cards in this game. If they don't agree, we can't do it.
Well, Judge, I think we can hold the jurors as the court thought in a room, and then if it becomes an issue at that point, I think we would have to look at the three factors that are in the case law and then make the decision after consulting with our client.
I think it's like a 1982 case, and there's nothing after that. Any thoughts from the state?
Well, I'm glad the court found the case that I'd referenced. I didn't bother to look at it, but I do recall that the defense has to agree to it, so it's really, the ball would be in their court at that point.
The judge was overturned in the case of 1982 because he replaced the juror.
Well, we don't want that to happen again.
I
now,
know.
do we, Judge?
That's why I'm glad I read the case.
I will say this. Judge Schrader's rulings during the first case did not cause the case to be overturned. There was no error by Judge Schrader in that first trial that resulted in this case being overturned on appeal.
So what I'll do is we will take 4 jurors. We will put them in a separate room, and they will have to stay there while the jury deliberates. And if we have an issue during deliberations, we will bring the attorneys back with the defendant, and we will decide what to do.
Thank you, Your Honor.
Okay?
Judge, just for figuring out where we're going to be, does the court allow the jury to deliberate well into the night, or is there a specific time?
That's a great point to bring up, and I think we should. If we want them to deliberate after 5, we have to inform the security ahead of time that they are available. And another thing is, I think we should have the jury have some input as to that also, because they might have some personal responsibilities that they have to take care of, like children.
Correct.
So
That's why we're asking, Judge,
yeah.
because as the court knows, we're about an hour away, so we
Yeah.
just want to make sure that we're planning it appropriately.
What we'll do is we'll try to maybe start talking to the jury like maybe 4 o'clock or 4:15 and get their thoughts. And if they want to stay, I'm going to let them stay. And then we'll have to inform security. Okay, one more quick thing. Did we figure out how much time you're going to talk on the closing, Ms. McNeil?
So I think it's going to be between an hour and 15 minutes and an hour and a half.
Wonderful. Mr. Perry, did you figure out how much time you're going to talk?
I don't know how long this is going to take me to get through.
All right.
Probably at least that.
Okay, what I'm going to do then, so the lawyers are aware, so everybody feels comfortable, I'm going to do my reading, and then we'll let the state do their closing, and we'll take a break. So the jury gets a little break, and then Mr. Perry, you can start after the break, okay?
Thank you.
And it sounds like we'll have to do the rebuttal right after lunch, unless we go a little quicker. Okay? Let's take 5 minutes, and we'll bring the jury out, okay?
So, what was
You're blocking our client from being able to see the jury.
Larry, you ready to stand?
That's where it was last time. Yeah, I'm pretty, oh, wasn't it? No, because I wouldn't have been able to see the jurors if it was there. They put it there and then we moved it back. It might have been right there, but I don't know. Jeremy thought it was there, but I would just have to see if he can see. Yeah, he is. He's not going to be sitting here. Was. Could he see everybody when it was forward? Could Mark see the jurors when the box was where it was for opening? Like,
Okay, we're good.
right there, I know you can probably see the jury, but if they move that box out and forward, are you going to be able to see the jury?
If they move it this way.
So stand next to there.
So that's good then? We're going to do it there?
But then the issues for the court, oh no, the court reporter will see.
Court reporter is going to see very clearly. She doesn't need to see that. She just needs to see the person speaking.
Right. So it is blocked. Okay, thank you.
I know. I don't rely upon. Go home and scrub that. Mackenzie's going to get you one.
You have to go?
Yes, I'm bringing water. There are some matters, but I should. You took this one. Yeah, he can see. I asked him. I went and stood there. So, no, where it was. That's fine. Yeah.
I heard that. I heard that.
15, 20 minutes. Depends how fast I read. All right, bring the jury out. We'll go on the record on Mark D. Jensen, 2002 CF 314. Let's have the appearances.
Good morning, Your Honor. The State of Wisconsin appears by Special Prosecutor Robert Jamboys, Deputy District Attorney Carly McNeil, and Public Service Special Prosecutor Beverly Jamboys.
Attorneys Bridget Krause, Jeremy Perry, and Mackenzie Renner appear on behalf of Mr. Mark Jensen, who appears in person. Good morning, Judge.
Good morning. The date is January 31st, 2023. The jury is back in the courtroom. Ladies and gentlemen of the jury, thank you for coming on time, having patience with us. We are going to do then closing arguments. Nobody has their pads and their pencils with them, right? So we're good on that. Just to give you a little heads up, all the instructions that I have to read to you and the two verdicts you're going to have, but I have to read the instructions to you. I will do that first. The state will do their closing first because they have the burden of proof, and then the defense will do their closing, and then the state has an opportunity to do a rebuttal. So, and we'll take a break in the middle of it so you won't have to sit here till 12 o'clock noon, okay? All right. With that, the court will now instruct you upon the principles of law which you are to follow in considering the evidence in reaching your verdict. It is your duty to follow all these instructions, regardless of any opinion you may have about the law is or ought it to be. You must base your verdict on the law I give you in these instructions. Apply the law to the facts in the case which has been properly proven by the evidence. Consider only the evidence received during the trial, and the law is given to you by these instructions, and from these alone, guided by your soundest reason and best judgment, reach your verdict. If any member of the jury has an impression of my opinion as to whether the defendant is guilty or not guilty, disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the sole judges of the facts. and the court is the judge of the law only. You are entirely free to disregard anything that counsel have said, or that I have said or may say about the facts. You are not in any way to defer to a judge merely because you think a judge has more experience and therefore might be wiser with respect to the facts. If at any stage you have thought that I have expressed an opinion about the facts in this case or upon how you should decide the guilt or innocence of the defendant, I assure you that you have misunderstood my intention. Neither previously nor now nor hereafter do I intend in any way to indicate how you should view the testimony of any of the witnesses or how you should decide as to the guilt or innocence of the defendant. Information is not evidence, and information is nothing more than a written formal accusation against the defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against the defendant in any way. It does not raise any inference of guilt. The accusation. The information in this case charges that on December 3rd, 1998, at the village of Pleasant Prairie, County Kenosha, state of Wisconsin, the defendant caused the death of Julie C. Jensen with intent to kill her. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. First-degree intentional homicide, the statutory definition of the crime. First-degree intentional homicide is defined in 940 sub 01 of the Criminal Code of Wisconsin is committed by one who causes the death of another human being with the intent to kill that person or another. The state's burden of proof. Before you may find a defendant guilty of first-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. The elements of the crime that the state must prove. Number one, the defendant caused the death of Julie Jensen. Cause means that the defendant's act was a substantial factor in producing the death. Number two, the defendant acted with the intent to kill Julie Jensen. Intent to kill means that the defendant had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. When must intent exist? While the law requires that the defendant acted with intent to kill, it does not require that the intent exists for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. Deciding about intent. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. Intent and motive. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of a defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all the circumstances. The jury's decision. If you are satisfied beyond a reasonable doubt that the defendant caused the death of Julie Jensen with the intent to kill, you should find the defendant guilty of first-degree intentional homicide. If you are not so satisfied, you must find the defendant not guilty. Burden of proof and presumption of innocence. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reasons, and prudence. Presumption of innocence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless in your deliberations you find it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The state's burden of proof. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt the defendant is guilty. Reasonable hypothesis. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you should do so and return a verdict of not guilty. Meaning of reasonable doubt. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based upon mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth. Evidence. Evidence is, first, the sworn testimony of witnesses both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes to the jury room. Third, any facts to which the lawyers have agreed or stipulated or which the court has directed you to find. Anything you may have seen or heard outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at trial. Circumstantial evidence. It is not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge or experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offense before you may find the defendant guilty. Improper questions. Disregard entirely any question that the court did not allow to be answered. Do not guess at what the witness's answer might have been. If the question itself suggested that certain information might be true, ignore that suggestion and do not consider it as evidence. Objections of counsel, evidence received over objection. Attorneys for each side have the right and the duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact an objection was made. By allowing testimony or other evidence to be received over the objection of counsel, the court is not indicating any opinion about the evidence. You, the jurors, are the judges of the credibility of the witnesses and the weight of the evidence. Stricken testimony. During the trial, the court has ordered certain testimony to be stricken. Disregard all stricken testimony. Exhibits. An exhibit becomes evidence only when received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received is evidence whether or not it goes to the jury room. Remarks of counsel. Remarks of the attorneys are not evidence. If the remarks suggested certain facts not in evidence, disregard that suggestion. Video recordings. You have seen previously recorded testimony of witnesses who are no longer available to testify in person. You should ignore the logo which may appear on these videos because it has no relevance to this case. You are further instructed that this recorded testimony is evidence and should be evaluated the same way as the witnesses who testified in person. Statements attributed to the defendant. The state has introduced evidence of statements which it claims were made by the defendant. It is for you to determine how much weight, if any, to give to each statement. In evaluating each statement, you must determine three things. Whether the statement was actually made by the defendant. Only so much of a statement as was actually made by a person may be considered as evidence. Whether the statement was actually restated here at trial. Whether the statement or any part of it ought to be believed. You should consider the facts and circumstances surrounding the making of each statement, along with all the other evidence, in determining how much weight, if any, the statement deserves. The weight of the evidence. The weight of the evidence does not depend on the number of witnesses on each side. You may find the testimony of one witness is entitled to greater weight than that of another witness or even several other witnesses. Jurors' knowledge. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experience in the affairs of life. In formulating your views of the facts, you are not to bring in to bear anything except the evidence you have heard in this courtroom. You are to ignore any immediate account or anything else you may have heard or seen about the case except what you learned in court. Expert opinion, testimony, general. Ordinarily, a witness may testify only about facts. However, a witness with expertise in a particular field may give an opinion in that field. You should consider the qualifications and the credibility of the expert, the facts upon which the opinion is based, and the reasons given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any expert's opinion. In resolving conflicts in expert testimony, weigh the different experts' opinions against each other. Also consider the qualifications and the credibility of the experts and the facts supporting their opinions. Hypothetical questions. During the trial, witnesses were told to assume certain facts and then was asked for an opinion based upon that assumption. This is called a hypothetical question. The opinion does not establish the truth of the facts upon which it is based. Consider the opinion only if you believe the assumed facts upon which it is based have been proved. If you find that the facts stated in a hypothetical question have not been proved, then the opinion based upon those facts should not be given any weight. The credibility of witnesses. It is the duty of the jury to scrutinize and weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and of the weight to be given to their testimony. In your determination of credibility, you must avoid bias, conscious or unconscious, based upon the witness's race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other personal characteristics. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors: whether the witness had an interest or lack of interest in the result of this trial, the witness's conduct, appearance, or demeanor on the witness stand, the clearness or lack of clearness of the witness's recollections, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any, has been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. There's no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. And in everyday life, you determine for yourself the reliability of things people say to you. You should do the same thing here. Defendant elects not to testify. A defendant in a criminal case has the absolute constitutional right not to testify. The defendant's decision not to testify must not be considered by you in any way and must not influence your verdict in any manner. Impeachment of witnesses, prior conviction, or juvenile adjudication. Evidence has been received that some of the witnesses in this trial have been convicted of crimes. This evidence was received solely because it bears upon the credibility of the witness. It must not be used for any other purpose. Impeachment of witness, character for truthfulness. Evidence has been received regarding a witness's character for truthfulness. You may consider this evidence in weighing the testimony and determining credibility. Closing arguments of counsel. Consider carefully the closing arguments of the attorneys, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given to you by the court. I will stop now with my instructions. I will read a portion later. At this time, the attorneys will do their closing, and anytime you're ready, Ms. McNeil, you can do your closing argument.
Good morning, everyone. 2023, this year, is the 25th year stolen from Julie Jensen. Birthdays and Christmases and new school years and graduations, all taken from her. When a person dies, their family is devastated, their friends mourn them and remember them. And after all this time, Ruth Vorwald, the first witness, cried thinking of Julie and remembering her death. After all this time, we heard from Angela Martinelli, Kim Noble, Carrie Ashley, Eric and Laura Shore, Therese DeFazio, David and Sharon Naring. We saw the videos of Ted and Margaret Voigt, Marion Passetti. Many, many good and wonderful people have died tragic deaths, but not many people, after all this time, would have so many friends and neighbors coming forward to tell you about them, to tell you what a kind, loving, devoted person they were, as Julie Jensen was. And it matters in this case because, yes, it is possible that even a mother with young children might end her own life, but that is not the evidence in this case. The evidence we have is that Julie told Ted Voigt, Margaret Voigt, Therese DeFazio, and the defendant's own sister, Laura Koster, about her fears that the defendant would kill her. Julie took pictures of things that troubled her in the defendant's day planner and gave them to the police. So the evidence here is not evil murder or tragic suicide. It's murder or it's suicide plus something else. Somebody committed a ghastly crime here. Either Julie Jensen plotted for weeks and weeks since at least mid-October 1998 to kill herself with a substance undetectable at autopsy, to plant evidence with her friends and the police and even in the computer that her husband was responsible, or Mark Jensen, who had tormented and punished and never forgiven his wife for years, found her replacement and then killed her. What a convenient suicide this was for Mark Jensen. Kelly Labonte wasn't just an affair. She was Julie's replacement. That happened, and it happened almost immediately, even without regard for appearances. The defendant didn't have to worry about losing custody of his kids or child support or alimony. How convenient. As an added bonus, he stood to gain $100,000 in the life insurance money, even if Julie's death was ruled a suicide. Julie's death was so convenient for the defendant that he couldn't even resist high-fiving his father after he got his house back from the police. He couldn't wait to throw away Julie's possessions to make room for Kelly. What excellent timing Julie's suicide was for the defendant. The timing was so good that she died before the kids got home on December 3rd, so the defendant didn't have to worry anymore about David's pleas for his mother. Now, this is hard to fathom, and it can be hard to wrap your head around the idea that a respectable member of society, a person with a great job, a nice house, 2 kids, a dog, a pool, an idyllic life, would poison his wife with ethylene glycol and then smother her to death. That's why Julie's affair and the years of harassment that followed matter, because it shows how the defendant felt about his wife. He hated her. What the defendant did to kill his wife is almost past understanding, except he hated her. For nearly all people whose marriages are falling apart, the answer is divorce, not murder. But the defendant hated Julie, and we can prove it. There's the email to his girlfriend. See it on the screen there? You can see the text of the email. Hey, can't forget about you. Can't, don't want to. I miss you. Then you see the email you've seen repeatedly. This is the email to his wife with the pornographic images attached to it. That shows you what he felt about his wife and what he felt about his girlfriend. How he wanted his girlfriend, he had Julie's replacement. And for him, it didn't have to be a divorce because he hated his wife. And now I want to take a look at this harassment that we've shown you before. I just want to take a look at a few things. First of all, I want you to see the extent of it. There's just page after page after page in this exhibit that we showed you of the harassment. It just keeps going on and on and on of Julie tracking it. And remember, we showed you yesterday the page where she was told by the police, hey, you got to keep track of this. You got to help us. So if we take a look at this, we just see some examples of what's happening. This is the page we showed you where she was told by the police to keep track of things. And again, a few examples of the type of harassment that was happening. One of the things that Julie said is it always seemed like the person who was harassing them just was one step ahead. 12/19/95, photos left in truck at Ruther during David's Christmas program. That's quite a stalker there. Finding the truck at Ruther during a Christmas program. That's amazing. That stalker is one step ahead. And then if we just go further, we heard in the testimony, too, the nature of this harassment. It wasn't just the hang-up phone calls. They would happen at home, but also, according to the defendant, they would happen at his work. The leaving of the pornographic images, they would happen around the home, but also, according to the defendant, they would be left at his work. Mailed to him sometimes, but often left on his vehicle at work. These pornographic images, penises and photos of oral sex, or what looked like a woman in position close to a penis. Those harassing photos. And we see more examples of that. Several hang-up calls at Mark's office, talking about David finding a tape. Found videotape in front of brick ledge of garage. Then hang-up calls asking how he liked the tape. Then various calls to Mark's office, soft, effeminate male voice referring to video. Photo left on Mark's truck at office. And again, we're not going to go through all of this. It just keeps going. And we showed you this page repeatedly too, the new tactics, which led to the notation of these harassing emails. And we recovered these emails. These were from the zip disk. They were found in the defendant's home, saved on what we would use nowadays would be a USB drive, a thumb drive or a flash drive. But back in the day, it was these zip disks. And what was found on the zip disk is the email that we showed you with the attachments. And because it's the actual email and not a screenshot, that's how we can see. It was from Mark Jensen to Mark Jensen, and he saved it, and he saved the images attached to it, and it was on those disks. I also showed you, too, that he saved some screenshots from a computer. And in the screenshots, I showed you in the background, you could see Trading Expert Pro was up in the background. So you know it's from him. So we heard about Julie's hobbies, gardening and crafts and book club. This is the defendant's hobby. This is his hobby. This is what he did for years and years and years until... Let's look when it stops. It trails off in June of 1998 and then ends entirely in August of 1998 when the defendant gets his girlfriend. Remember, Julie was alive for months afterwards, but there's no more notes in this harassment log because the defendant has a new hobby. The last thing I want to note about this, 6/19/98, definitely found Mark's new office phone number, ranted, raved, and swore at the receptionist, several hang-ups at the office after that. This was after Mark had moved to Stiefel Nicholas. We heard from the receptionist, Meredith Perez. She never got a call like this. Just more proof that this was fabrication. And think about the torment to Julie, because although Mark is reporting these things, who's at fault? It's her, because it's the man she had an affair with. And she has to tell the police about it. And when she tells the police about it, she has to repeat over and over and over again that she had an affair. And she even asked for one police officer, please, Pleasant Prairie, just send me one police officer so I don't have to tell the story again. We even have the defendant making Julie think the pictures were her. And if you saw this email, you saw how he would do it. In this email, the harasser is pretending that he's taking a picture without her knowing it of a married girl that he's currently doing. Just the kind of trickery that was used with Julie. The man she had an affair with must have taken secret pictures of her. And now these are pictures of her that he's leaving around. This is gaslighting. And Julie's a smart person, but she's just constantly being lied to and deceived by her husband. And she's told by the police and the private investigator, hey, we think it's your husband, but she doesn't want to believe it. Now remember the defendant's interview. We showed you several clips from that recorded interview, not the greatest recording, 1998. But we showed you several clips from it, the defendant's own statements. And the defendant was confronted by Detective Ratzberg about this harassment. And what the defendant said, well, he said he'd find them around the house, these pictures, because he did. He'd find them around the house, but it was a question of showing them to her. He said he did end up showing a majority of them to her. And then here's what he said. How many times do you have to see pictures like that and get reminded of it before you kind of go, man, it's not worth it. It gets old and you put it away. And I'd put them away and then something would happen and I'd get pissed off and I'd pull some out and I'd say I found these in the shed. Then the question was, when in fact you had them? And Mark says, I had them. I mean, they'd accumulate for weeks. How many times do you have to see pictures like that? Who has an interest in exactly those kind of pictures? That's why this evidence matters, because Mark's obsession with these types of pictures, with these penis photos categorized on his computer, with photos of oral sex, this obsession was his, and those are exactly the harassing pictures that would be left around. And yet he acts to the detective like, how many times you got to see it? He wants to see it. That's what he wants to look at, so we know it's him because of that too. And it's another lie to the detective. Remember how much Mark Jensen struggled when asked about Kelly Labonte? He just wouldn't say, even at the present moment, that she was his girlfriend. He, of course, wasn't going to admit to the affair before. But even in the present, he couldn't say she was his girlfriend. She had moved to Wisconsin at that time. She'd moved for him. But he wouldn't say it. So I said from the outset, the defendant was under no obligation to forgive Julie. If he had filed for divorce after the affair, you know what? Even if he did hate her forever after that, as long as he ended the relationship with divorce, then we wouldn't be here. But he never forgave her. That's what his friend from work, David Naring, said. That's what his friend noticed. Julie knew it too. It's one of the last things she said. She told Dr. Borman on December 1st about that affair and how she thought the defendant had never forgiven her. And that's not the only thing that Julie said on December 1st. Because even though her marriage was falling apart and she was miserable, when she was asked about depression and whether she would ever kill herself, she said never. She would never leave her boys. And how many witnesses did we hear from in this case? It was a lot of witnesses. Not a single witness, not a single one testified that Julie Jensen ever made suicidal statements, that she ever had suicidal ideation, that she ever made a suicide attempt. Not a single one. Instead, what we can see in the evidence through the computer evidence is the timeline of the defendant's plot. That's why those emails with Kelly Labonte, the defendant and Julie's day planner, their respective interests matter, because we can see the defendant's life reflected in those internet searches, that internet activity, and we simply do not see anything similar for Julie. Remember how dismissive Dr. Thomas was of Julie's lack of computer knowledge? You are to decide this case based on the evidence, not on cognitive bias. not on some make-believe story that's unsupported by the evidence. In contrast with the defendant, we have evidence that Julie Jensen was very unfamiliar with computers. That's the evidence. The very beginning of September 1998, that's when she has that conversation with Therese DeFazio. Therese specifically asked her about helping in the computer lab, and Julie said no. She was there to be helpful, but she just couldn't. She just didn't know about computers. And they joked about how slow she typed, 35 words a minute. Then we have Julie applying for the job at Bradford High School. Joe Mangy told you about that. Well, back in 1998, that job she was applying for, even for a high school, even an office in a high school, it wasn't a computer job. The secretaries at that time didn't even have computers. So Julie was very well qualified for that job. And when Julie had that conversation with Therese DeFazio about her being afraid the defendant was going to poison her, how she had seen the defendant on the computer, but he would turn it off or cover up the screen, Ms. DeFazio suggested, well, maybe she could look at the computer cache and maybe she could see what the defendant was up to. And Ms. DeFazio was familiar with a Macintosh, and so that's what she was suggesting. But Julie said she didn't know how to do that. She wouldn't know what to do. Ms. DeFazio even remembered David doing what kids do, right? They blurt something out about their mom. Oh, my mom doesn't know anything about computers. And it's funny, I'm teaching her. And it started a whole class discussion where all the other little kids joined in. And Ms. DeFazio explained, well, that was normal back then. Computers were just getting in the home in 1998. I am going to emphasize once again, you are to decide this case based on the evidence, so I am going to show you the evidence. And I'm going to go through that with you because what I say or what they say, it doesn't matter if it's not supported by the evidence. So let's look at the timeline of the defendant's plan that we can see through the computer evidence. So we've seen this before, the dates and the times of this computer use. Now, the argument that you've heard from the defense is that, well, there's no computer use during normal work hours because Julie wouldn't have wanted to block the phone line. That argument is absurd and it's unsupported by the evidence because not only is the internet on this home computer not used during normal work hours when the defendant wasn't home, but it also wasn't used at all when the defendant was out of town. So let's look at September. September 2nd, we zoom in. September 2nd, no internet activity. The defendant's in St. Louis. How do we know that? We have his day planner. We also have those emails. Here's the email from Kelly, September 3rd. Thanks again for yesterday. They were together in St. Louis on the 2nd. There's no internet activity on the 2nd. Let's go to later in September. We have another trip to St. Louis. We have computer activity, internet activity, the early morning hours of the 11th, but then the defendant goes to St. Louis that day, 11th and 12th. And again, how do we know it? It's right here in his day planner, and it's in the emails. Let's look at what Kelly had to say about that time frame. Her email, September 9th. She says on the bottom, a massage tomorrow and you the next day. How perfect can one life be? Tomorrow the 10th, the defendant the next day, the 11th. Let's go to October. The defendant and Kelly Labonte are in Appleton. No internet activity those days. This is the time period when the defendant and Kelly Labonte are going to Appleton. They're going to open up that office, the office where Ed Klug works. So this is where the defendant would have met Ed Klug in person and where the other people opening that office noticed there was something going on. between the defendant and Kelly Labonte. So now, what about Sunday, October 11th? We do have internet activity in the afternoon on that day. It's afternoon internet activity. Maybe this is Julie. Patagonia. It's the Patagonia website that's being looked at. And then what do we have the next day? Email from Mark to Kelly. This is where he's trying to buy some things for his girlfriend, right? A treat, spoiling his girlfriend. Now imagine we didn't have these Patagonia emails to Kelly. How much do you want to bet Julie would have been blamed for these searches for women's clothing? How much you want to bet? She would have been blamed for this computer evidence, but we know who was searching for Patagonia that day. Moving on in October, the trip to Chicago, the very suspicious trip to Chicago. Who needs to stay in a hotel in Chicago when you live in Pleasant Prairie? Well, that's what you do when you're planning a nice long getaway with your girlfriend. And we see it in the day planner, October 21st, 22nd, 23rd, 24th. That's the trip to Chicago. And we see it in the emails. Chicago is the subject. Oakbrook will move on 10/23 and open for business 10/26. Where is Oakbrook in relation to the airport? Any ideas? So this email, right, this planned get-together between the defendant and his girlfriend, that happens on October 12th. The early morning hours of October 13th, we have the defendant on the computer planning the Chicago trip. The O'Hare Marriott, Morton's Steakhouse. Then on October 15th, I'm showing you this because it mirrors the defendant's life. On October 15th, we go from Bass Pro Shop to Big Cedar to Windstar Cruises, and we know these early morning searches are the defendant. He's the fisherman, so he's going to Bass Pro Shop. He talked to Kelly about Big Cedar, so he's going to this website. Then Windstar Cruises, early morning hours of October 15th. And what is the next email to Kelly Labonte? This string of emails from October 16th, 1998. Hey, want to run off somewhere? I do love you. Kelly responds, what sparked this bold attempt at messing with me? Sounds wonderful. Where should we go? The defendant says, really bold attempt. If it was really bold, you'd have tickets for the Windstar in your hand. Who was on the internet looking for Windstar? It's obvious, right? These emails are important on October 16th with Kelly Labonte because the defendant has decided he is planning his future with Kelly. He misses her, he wants her, he loves her. He's buying things for her, and he wants to sweep her off her feet with this cruise. Here's what Kelly says. Considering you have a milestone birthday next year, and we would both need some time to clean up our lives, so to speak, I was thinking what a lovely way to spend your birthday. You, me, sunsets, ocean, champagne, no outside issues. See, Kelly understands the practical implications of what the defendant is doing. You just don't go on an expensive, lengthy cruise with your lover on the side. That isn't realistic. So that transforms this conversation into what are you going to do with your spouse? And so Kelly wants time to decide. She wants until the end of the year to decide either way what to do with her issue. The defendant says, fair enough, no deadline on deciding, whatever time needs to be figured out. And then Kelly starts asking him, well, what are you going to do? Do you have it all figured out? The defendant says, I'm thinking so, but then is mostly talking about her, barring seeing a bunch of disgusting habits. Some details to be worked on, but then those are just details, not the big issue. But Kelly wants to know. She wants to know. It was the details I was wondering about. That's what she says. And the defendant just keeps on being vague. Murphy spins on details. Details are just noise in the bigger picture. Kelly, again, and you plan on dealing with the details how? One at a time. So at that point, that's when Kelly says, evasive little shit. Kelly wants to know, what is he going to do? She's asked for the end of the year to deal with her issues, but he's not telling her what he's going to do with his. The defendant isn't telling her what he's going to do with his wife. Kelly calls him out for it. But what we know from the computer is the defendant is forming a plan. He's planning for a future with Kelly by searching for Windstar Cruises, and he's planning for a future without his wife through the other searches on this computer. So it begins with this series of searches on October 16th, 1998, and it starts at 1:54 a.m. I'm not going to show you all of these again, but these are the searches that go from underground to drugs to botulism and ending with poisoning. Then we move to the evening of October 16th, 11:57 p.m., and disturbing searches continue. First, we start with the pipe bomb article. This was the one about the man who was attempting to kill his estranged ex-wife with a pipe bomb. And this browsing session, this one continues for over an hour until about 1 a.m. And I want to show you the various websites that are accessed in this browsing session so you know who is on that computer and doing these searches. We go to the Mercury Fulminate website. Now I want to zoom in a little bit here. So we go from the pipe bomb article to mercury fulminate is used as a primary explosive in the fabrication of detonators. Then we go to material required. We have here a list of things including glass containers, tape, syringe. Then we go to a warning. Caution. Acid will burn the skin and destroy clothing. Then we go to this. This is the list that Julie found in the defendant's day planner. It's what she took a picture of. We wouldn't have this if she didn't take a picture of it because it wasn't in there anymore when the defendant's day planner was recovered by the police. So what we see here on this list, and we'll come back to this, but we see bottles, booze. So those could be glass bottles. And then we see syringe on this list. Then we see bag hands, like maybe if acid will hurt your hands. Maybe if you've seen that warning on that website. And next we have a website accessed about pool fun. This pool fun article, it talks about reversing the polarity of a pool. And the article claims that that'll cause an explosion. And again, is this true? Is that how that works? I don't know. But that's what the user of this computer, the defendant, was seeing and what he was looking up. And what do we have next? Nicotine. That's the next search. Who's the smoker here? It's Mark. Julie doesn't smoke. So we go to this nicotine search, the nicotine searches. Let's go back to this list. Nicotrol. That is the stop smoking drug that Dr. Borman prescribed to the defendant. Librium. That's also the defendant's prescription. His own drug supply. Who do you think is on the internet doing these searches? And just in case you weren't sure, these are the searches that end the browsing session. They're for Stiefel Nicholas employees. We see the Appleton office here. Remember that address? 740 Ford Street? It was in the defendant's planner, and David Thompson knew it too. Then for some reason, we're going to Colorado Springs. The employee, the branch manager, John Jock Joseph. We heard from Kelly why the defendant was very interested in John Jock Joseph. Because as we learned, the defendant had exhaustive conversations with Kelly Labonte about every man she had had any sort of sexual encounter with, including detailed descriptions of that man's penis. And Kelly Labonte knows that in the beginning it wasn't so detailed, but she did tell the defendant about John Jock Joseph, including a description of his penis. And she remembers that it was the fall of 1998, and she remembers it was before the Blueprint conference because she remembered seeing him with the defendant, seeing John Jock Joseph and kind of pointing him out to the defendant. They had talked about this man before. There is absolutely no reason why Julie Jensen would be so interested in John Jock Joseph, but we know the defendant was. Then finally, we have the search for Kelly. So why is the defendant searching for Kelly? He knows her name, he knows where she works. But it's a search for Kellys, right? They're all Kellys here. What he wants to know, what the defendant is very interested in, is her last name. Kelly's married by this point, but she hasn't changed her last name yet. The defendant's trying to gauge her relationship with her husband. Has she bothered to change her name yet? Is she really committed to this new marriage? He wants to know, and so he's checking. Oh, she's still Labonte K. And that's how this browsing session ended. October 19th, early morning hours, another search for pipe bomb. Maybe Julie Jensen wanted to build a pipe bomb. Then we have the infamous Blueprint Conference. We see it reflected in the defendant's day planner. This is the conference in St. Louis, the early morning hours of November 7th. This is when the defendant was out drinking with a group at first, then the bar or club closes down, then they're in the lobby hanging out talking, and he ends up alone with Ed Klug. And they were wife bashing, and the defendant told Ed Klug about wanting to kill his wife, looking up ways on the computer to kill his wife, finding something that would crystallize you from the inside out. Now, we saw that video of Dawn Cooper, and I guess she was supposed to demonstrate that maybe that conversation didn't happen because she was also out in the lobby after bar close. But what happened in the end is she said that she left, and the only people there from her group were Mark Jensen and Ed Klug. And we know that it happened. We know that the defendant told these things to Ed Klug because of Joanne Klug. We know that Ed Klug talked to her multiple times the early morning hours and then again later in the day at the airport. She and Ed have been divorced for years now. I think they said it was finalized in 2013. She's never had a reason to lie about this. It's a very memorable conversation. They even have the phone records, right? Really, he was talking to his wife at those early morning hours? Well, yes, he was. Look at the phone records. And Joanne remembered something in particular. She remembered when Ed was at the airport, and she was thinking about, kind of ruminating on what Ed had told her, and she was confused because she was wondering, well, how does someone die from Benadryl? She remembers Ed telling her about the Benadryl. And so at the airport, she asked him that question about the Benadryl, and that's when Ed says to her, it's the antifreeze. Joanne Klug came in here and she had no reason to lie. She's long done with Ed Klug. But the truth is that conversation happened. And Ed told Stacy Bauer too. She remembers fewer details than Joanne. What she remembered is hearing that the defendant hated his wife and wanted her dead. But she does remember her immediate reaction when she heard less than a month later that Julie Jensen was dead. Oh my God, he killed her. And Stacy Bauer's opinion doesn't matter. It's not of significance. But what matters is she didn't know the Jensens. The only information she had was from Ed Klug. She knew what Ed Klug had told her when she made that statement. So we know that when Ed Klug got back from the Blueprint Conference, before Julie Jensen died, that he told Stacy Bauer about this deeply disturbing conversation that he had had with Mark Jensen. So that when Stacy hears Julie is dead, that is her first thought. Oh my God, he killed her. Finally, we know this conversation with Ed Klug is true. And we know how damning it is based on the defendant's reaction to it. And that's David Thompson. David Thompson is quite a character. He was in pretty big trouble in 2007. But whatever you want to say about him, when he came to court to tell you what had happened, what the defendant was up to, when he came to court to testify, he wasn't getting out of anything. He admitted he was a bank robber, but he's overcome that, and there's nothing to offer him today because he's not in trouble. Coming here for him was just an inconvenience. And with David Thompson, we have those recorded phone calls from the jail. We know that in the defendant's mind, this plot was real. This plot to sit on Ed Klug, so his testimony would never be heard. And we heard from the video of Nathaniel Clanton that this was the stupidest thing the defendant could have ever done. That's what he thought. But that's how desperately the defendant wanted to silence Ed Klug. There's absolutely no reason for David Thompson to get on the phone with the mother of his child, Kim, and give her Ed Klug's name and work address. The same thing that was in the defendant's day planner, the same thing that was on that internet search. There's absolutely no reason for David Thompson to tell Kim to say everything is as planned to the defendant when he gets on the phone. There's absolutely no reason for the defendant to be asking Kelly to give his parents $500 twice in the most evasive conversation possible. There's absolutely no reason for the defendant to be insistent that his mother get in touch with Kim in multiple calls, except that in the defendant's mind, this was a real plot. And think about that. Why didn't the defendant just leave it to the law and his lawyers? If Ed Klug's a liar, then that's what cross-examination is supposed to show. Cast doubt on him as a witness. And in fact, that's what Nathaniel Clanton said when the defendant discussed this plot with him. He's like, if you think you can beat your case, then why do you need someone to take a witness out? I want you to think about the defendant's thought process. There is a lawful, legal way to challenge Ed Klug's evidence in this case, just like there's a lawful, legal way to end your marriage with the wife you hate. But that's not what the defendant chose. And he's acting all cagey in these phone calls, thinking he's too clever to get caught. And even when talking to his mother, he references, gotta be careful on the phone. This weekend, when we know the defendant was in St. Louis, no internet activity. Once again, we see that pattern. But this weekend is significant in terms of what happened to Julie. She got sick that weekend, and kind of inexplicably so. She threw up on the carpet. And we know that this happened because that carpet cleaning bill, that's from that Monday, the 9th. She threw up on the carpet, and you can see it in the bill. It's also referenced in both of their day planners. Now, this is strange. For an adult to be so sick that they're throwing up in the carpet of their home, that's kind of how kids get sick. Very strange for an adult to be sick in that way. And we know Julie took care of the house, but she was so sick she apparently couldn't clean the carpets. She must have been really sick. Aaron Dillard knew about this. And this is how he explained the defendant cracking. Going from the defendant saying, this is all bullshit, and I didn't do it, to the confession. The defendant had been talking to Aaron Dillard about his case, getting advice from Aaron Dillard, like get those samples retested, which happened. He had been complaining a lot about Ed Klug. Then he told Aaron Dillard that he wished he hadn't made that mistake, had that drunken conversation with Ed Klug, said that's essentially what was screwing him in his case. And he said that it was on his mind because he tried to poison Julie before he left on that trip. He said he was lucky in a way that she didn't die because he really would have been screwed after saying what he said to Ed Klug. Aaron Dillard knew this, and Aaron Dillard said this, and Aaron Dillard described this admission from the defendant, opened the floodgates for the rest of the defendant's story. And this wasn't in Ed Klug's testimony. Ed Klug didn't know about Julie getting sick. Now, it was in Ted Voigt's testimony. That testimony, though, it didn't happen until January 2008. So that's half a year after Aaron Dillard came forward. And this is what you saw in that video the first week of trial. It seems like long ago now. But Ted Voigt talked about a time when Julie said she was throwing up. And he talked about how suspicious Julie became of the defendant trying to get her to drink something. And he described how Julie was telling him about the defendant trying to get her to drink some wine, and she didn't want to. And he was so insistent that it became a big argument. And I hope you can remember Ted Voigt's testimony, or at least look back on your notes. Because you see, that's the thing. This is such a massive case. There's so many facts and there's so much evidence, and it's hard to keep track of and wrap your mind around. And this incident with Julie getting sick that weekend, that's one of those hidden facts. What's the significance of it? Well, how would Aaron Dillard know? He was with the defendant for less than 4 days. How would he know? Why would he pull out that little fact? Unless the defendant told him, and told him that it was significant. So let's go to our next group of searches. The next timeline the computer gives us, November 10th, 1998, once again, the early morning hours. Here's the search for suicide. So maybe this is Julie. Maybe she's on the computer searching for suicide, joining some kind of suicide group or whatever. Let's see what comes next in this browsing session. We go to physician-assisted suicide, leading to a website about an advocate for physician-assisted suicide. Is 40-year-old Julie Jensen a good candidate for physician-assisted suicide? She's healthy. She has 2 young children. She doesn't have a terminal illness. What do you think Dr. Borman would have said if Julie came and asked him about whether physician-assisted suicide was for her? This search makes no sense for Julie. It does make sense for the defendant who's looking for a way to kill. Next, we have a toxicology website. Toxic alcohols. Ethylene glycol. (2:57 a.m.), so right along this same browsing session, we're back to nicotine. Now, we can't actually see every website that was visited. As Jason Ruff from the Wisconsin Department of Justice explained, we have the internet history, that's the Excel file, but we don't have the HTML files for all the websites visited, which means we can see that there were websites visited, but we can't actually see them on the screen. But even though we can't see the websites themselves, let's look at some of the websites that were visited on November 22nd, 1998. So 11:22, 4:50 p.m. Oh, 4:50 p.m. This is a Sunday. We have Anatomy Atom, poison. Anatomy Atom, that website comes up a lot on December 2nd and December 3rd. Then we have a Yahoo search, 11:22, 5:01 p.m. for drug interactions. Remember David Naring? David Naring knew the defendant told him that all the time the defendant was looking on his computer at work for drug interactions. Before Julie's death, after Julie's death. Just like Dave Naring said the defendant was looking for drug interactions, so we see it on the home computer. Then we go to the top and we get what looks like prescription list, rxlist.com, drug. Could that be Benadryl? At the very top, could that be diphenhydramine? Generic for Benadryl? All of these searches within minutes of each other, 11:22:98, a Sunday. Now let's go to 11:26:98. Got some science units, measurements. This is all 11:26:98. 11:06 p.m. Potassium chloride. Pool solutions. Then 11:29:98, Sierra antifreeze. That website was accessed. 11:29:98. We know the computer history was deleted that day. So December of 1998, these are very significant searches that we're going to look at. This activity. Now we see there's something at 1:18 a.m., but that's actually not a browsing session. That was just one HTML that was accessed. So really in December, when we're talking about the browsing sessions, this is what we're going to be talking about. So we know about December 1st We know that's the day that Julie goes to Dr. Borman, and we know that that's the day the defendant gives her the first dose of ethylene glycol, because by the early morning hours of December 2nd, she is showing the symptoms of ethylene glycol intoxication. She's acting drunk. That's the first stage of ethylene glycol poisoning. And so what happens when Julie is acting drunk in those early morning hours? 4:35 a.m., we have the search for paroxetine. Paxil. That's the antidepressant. And so this is when the defendant goes on the internet and he looks up this website for paroxetine, Paxil, and he shows it to Julie, and he shows her all those side effects, a ton of side effects, as a way to soothe her worries, because she doesn't know why she's acting like this, why she's feeling like this, but she went to the doctor and she got that medicine, and so now there's an excuse. This doctor visit was very important to the defendant. Julie was scared. She wasn't just going to drink or eat what the defendant gave her, particularly when he was trying to force it on her, just like with the wine. But what if instead of force, he used deception, something he's very well practiced in? What if he behaved how Julie wanted him to behave all along? What if he acted like he cared? What if he acted like he was concerned? What if he was good to her? He's making sure she's taking her new medication, something to drink along with it, and when she starts feeling these strange effects, he has something to blame it on, something he can show her on the internet, something to soothe her. Remember the morning of December 2nd? Julie Jensen talks to Margaret Voigt on the phone, her neighbor, and she sounded drunk. And that wasn't Julie, right? Every single witness who knew Julie told you she would not be drunk in the middle of the day. She sounded drunk because she was in the first stages of ethylene glycol poisoning, and Margaret Voigt was worried about her. But Julie said that Mark got the kids to school and he was being good to her. Right before that search for paroxetine or Paxil, we have a bunch of searches for Volvo cars. And this only matters because then we know it's not Julie. If she's sick, if she's feeling very strange, if she's looking for a reason, well, she's not looking at Volvo cars first. So that is the first internet activity, 4:31 to 4:35 on December 2nd. And I'm going to go through this internet activity in detail with you because this is an enormous case with so much material and so many witnesses and so much detail, but it's actually really simple. The person who was on this computer looking up ethylene glycol poisoning killed Julie Jensen. And I'm going to show you it was the defendant. So let's go. We're going to go to the second group of these searches, 8:14 to 8:49 a.m. And this is an unusual time to see internet activity on this computer, a unique time. And what we know about the morning of December 2nd is that the defendant didn't go to work. He got the kids off to school, David on the bus, Douglas to daycare, but he didn't go to work because he was going to Dr. Borman's that morning. So what happened in this next group of internet searches? We are going to see searches for ethylene glycol poisoning and specifically websites that include the symptoms of ethylene glycol poisoning. So I'm just going to page through these searches. Ethylene glycol poisoning, that's the first one. Oxalic acid, we learned that that's one of those breakdown products. Hard to say, I think it's fomepizole. That's the antidote. toxic alcohols. How do patients with toxic alcohol ingestions typically present? We're getting to symptoms. Now for a moment, we're back to paroxetine, Paxil. What follows that? Ethylene glycol. We're seeing the symptoms: development of acidosis, tachycardia, hypertension, cardiogenic shock. And again, whether this is true or not, this is just on the internet, but this is what the person in front of the computer saw. So why is this research happening at about 8:15 a.m., starting at about 8:15 a.m.? The defendant has a problem. Julie has begun experiencing this first stage of ethylene glycol symptoms, and she's already worried about it. She's worried about it, and the defendant needs to know what's coming next, and he needs to know how to pacify her, or better yet, sedate her. So he decides to go to Dr. Borman. And this is what we saw from the defendant's book. Kelly told us about this book, how the defendant is planning to make some money off of this book. And he describes this trip to Dr. Borman, talking to the receptionist counter, explaining how yesterday Julie was here to see him. Let's look at his description of what he was doing. Wearing an expensive suit and a Rolex gives a presentation of authority and genuine legitimacy. And when accompanying a reasonable and polite request, frequently achieves the desired results. Really gives you a glimpse into the defendant's mind. He goes to Dr. Borman, he's got his suit, he's got his Rolex, he's giving a presentation of genuine legitimacy. Why does he have to give a presentation of genuine legitimacy? This trip to Dr. Borman isn't legitimate at all. And unfortunately for Dr. Borman thought it was. You heard in Dr. Borman's testimony, he had the best interests of Julie Jensen at heart, and he thought the defendant did too, and that's why he gave the defendant that prescription. But Dr. Borman told you that if he had known all the facts, what exactly was going on, he would never have given that prescription to the defendant. But the defendant had this air of genuine legitimacy, and he knew it. So this leads us to the third browsing session on December 2nd, 11:45 to 11:47 a.m. We know the defendant had that Ambien prescription in his hand by 11:13 a.m. That was the video of Mark Hunter. He was shown that picture of the Walgreens thing on the counter. 11:13 a.m., that's when he got that Ambien prescription. It's right on the Walgreens receipt. And we know that he wanted to give Julie the Ambien right away. That's what the defendant said in his interview, that recorded interview. Julie's first Ambien, he gave it to her Wednesday morning. So he goes home, he gives her the Ambien, and he gets on the internet. Anatomy Adam, that's what this website is. The one with the poisons. Down there at the bottom. Go to E. Ethylene glycol. Once again, we have poisoning caused by ethylene glycol. We have the symptoms. Symptoms listed: rapid breathing, skin, lips and fingernails blue, heart and blood vessels, rapid heartbeat, low blood pressure, headache, stupor, unconsciousness. Then we have a gap, 11:45 a.m. to 11:47 a.m., nothing until 9:31 p.m. So what happened after that? What is happening on December 2nd for the Jensens? The defendant, we have no reason to doubt this, he did go to work in the afternoon. David's at school, and we know that that's the day Julie was supposed to go to school. That's the Wednesday, but she didn't make it to Therese DeFazio's class that day. And David had the note, and David's note asked if he could go to Eric Shore's house. So David isn't coming home from school on the school bus. He's going to his friend Eric Shore's house. And Douglas is in daycare full-time now, starting that week, full-time daycare. And so the defendant and David and Douglas are not back at that house. In fact, they had karate that night. So they're not back at that house until like 6:30, 7 at night. During all this time that Julie is alone, no internet activity. This is the night where the defendant had to cook because Julie was in bed. He makes mac and cheese. And how was Julie doing during this time period? What was her condition in this time period? Well, the defendant told Paul Griffin in one of those recorded phone calls how Julie was doing. The defendant said, the night before, that's the night when I made the mac and cheese, botched that real good. She wasn't even awake much. I mean, she was in bed the whole time. I mean, she was sleeping most of the time. I think the kids were being quiet to not wake her. I mean, there was some conversation that night, but she was pretty much out of it. So while Julie's pretty much out of it, what's happening on the internet? 9:31 p.m. to 9:43 p.m. Antifreeze poison. Poisoning caused by ingestion of antifreeze with the symptoms. Breathing rapid. We know that was happening. David saw that. Hypoxia. Lips bluish. Fingernails bluish. Skin discoloration, bluish. We saw that as one of the symptoms. Blood pressure, low. Hypotension, low blood pressure. That's what was happening on the internet when Julie was pretty much out of it and didn't leave her bed. Now we're moving to 12:03. The early morning hours, this browsing session on 12:03. 12:44 a.m. to 1:23 a.m. Antifreeze poisoning. How do you think Julie's doing? 12:43 a.m. to 1:23 a.m. Well, we kind of know how Julie's doing. Unconsciousness. Consciousness decreased. Here's another search. Ethylene glycol poisoning. Hypertension. Pulse bounding. Here's another symptom we saw. Tachycardia, fast heartbeat, pulse bounding. Here's another one we saw. Cardiogenic shock. Pulse weak or absent. You know how sometimes you go on the computer because you got like a pain in your side or something's happening with your neck or whatever? You ever look up pulse weak or absent for yourself? How about unconsciousness? You ever look that up when you're experiencing that as a symptom? We know how Julie Jensen was doing from 12:44 a.m. to 1:23 a.m., not because she's on the computer looking up these symptoms, because the defendant is. He's hoping she'll be dead by morning. So then we go to the last browsing session on this computer, 9:40 to 9:42 a.m. on the 3rd. But let's talk first about how Julie was doing the morning of December 3rd, the morning of her death. David said that his mother was breathing very heavily, raspy, labored breathing. He told his friends about it. He later told the detective about it. He asked his dad to take his mom to the hospital, and his dad said no. But his dad said, if she's worse later in the day, we'll take her. What does the defendant say about it? And we know the defendant said this. This is all from that recorded interview. Okay, that's not in dispute, what the defendant said about it. Various points within the interview, he's asked about this multiple times. She couldn't get out of bed that morning. The defendant says, you can ask David. She couldn't get out of bed. He wanted to stay home because mom was sick. She was asleep in bed. The defendant says, there was a question between myself and the kids that morning, whether or not to call an ambulance. Take her to the hospital. The kids wanted to stay home. Her breathing was funny. The defendant says from 6:30 in the morning, she was not able to get out of bed. I mean, she was groggy, almost incoherent, breathing very labored, raspy. The defendant said, I'm not even sure she was coherent. The defendant was asked if Julie sat up in bed. The defendant says, David tells me, we talked about it, David tells me that I was holding her up, supporting her. That's the part of the interview where the defendant talks about those 3 Ambien pills. One Wednesday morning, one Wednesday night, another one Thursday morning after the kids went to school. The defendant says he had to bring her water because she couldn't get out of bed. David told us the last memory he has of his mother is she said, I love you, and he said it too. What David said to the defendant, what the defendant said in his interview is that David told him mom couldn't talk that morning. I'm glad that David's last memory is I love you, but what he was saying to his dad was that his mom couldn't talk that morning. The defendant repeats again, she couldn't get out of bed. He talks about the sleeping pills and how the day before he couldn't rouse her at all. Then finally, we have that recording between the defendant and Paul Griffin, Julie's brother, talking about that morning, December 3rd. The defendant talks about he sat behind Julie on the bed supporting her when the kids came in, getting ready for school. The defendant says she was weak enough by Thursday. If she could have gotten out of bed, it would have been crawling. Who's on the computer that morning at 9:40 a.m.? We know the defendant wasn't at work. We know he wasn't at work. 3 coworkers say that. We have Ruth Vorwald and her sister, and we have Ted Voigt. All of them, those witnesses, place the defendant either going to his house or at his house, arriving to his house between 9:15 and 9:30 a.m. that morning. He had to get Douglas to daycare. He went to pick up a check from someone down the road, but those witnesses say that he was at his house or going to his house between 9:15 and 9:30 a.m. And here's the defendant's dilemma. He was hoping when he left that morning that he would come back and Julie would be dead. But he comes back and she's still alive. So he goes on the internet one more time. That search, when Julie was incoherent, when she couldn't get out of bed, when David said she couldn't even talk, there's that search for ethylene glycol poisoning. Then we go to a website for diabetic ketoacidosis, because we learned in the medical evidence that you get acidotic from this ethylene glycol poisoning. And apparently something similar can happen to a diabetic person in crisis. The defendant's looking at that too. The last thing on the computer, ethylene glycol poisoning. This is why the defendant ultimately suffocates his wife. She would have died from ethylene glycol poisoning, untreated as she was. But the defendant can't take her to the hospital. And first, when he comes home and she's not dead, he hopes if maybe he just turns her. We know she's unconscious because of how her arm is under her body as he turns her. He's hoping if he just turns her, maybe has her face in the pillow, maybe she'll just die. And he leaves and he comes back. But she's still alive. She didn't die, and he promised, and he's running out of time. And Aaron Dillard was able to put into words what the defendant did. Aaron Dillard gained the defendant's trust, as Aaron Dillard does. But the evidence was all there to begin with. That promise to David, Julie's body, how it was positioned, the medical evidence of the hemorrhage, the suffocation. Dr. Chambliss suspected suffocation from the very beginning. So there's things we're never going to know in this case. We're not going to know what the defendant did when he didn't go to work on December 3rd as he claimed. Dave Naring, Rosemary McGinnis, Meredith Perez, the receptionist at this small office, they all know he wasn't there that day. What exactly was he up to? What exactly was he doing? How exactly did he clean up? What did he do with the ethylene glycol he used? What about the juice that he put it in? Was that juice still in the fridge, or did he clean that up like the ethylene glycol? One thing we do know is the defendant did try to clean up. One of the reasons I spent all this time showing you the internet history is that the defendant never wanted you to see it. He deleted the internet history on this computer. We know he deleted it 11/29, 12/2, and 12/3. It's only because the police had the foresight to seize this computer in 1998, and only because the computer was analyzed by experts at the Wisconsin Department of Justice to see and get this deleted internet history, the defendant didn't want you to see it. Now, it seems that in this case, everything is blamed on Julie Jensen, but remember, this isn't a murder or just a sad suicide. It's a murder or a suicide and a frame-up. If this was Julie Jensen on the computer, and I've already showed you that that's impossible, but if this was Julie Jensen on the computer, hypothetically, why would she delete that internet history? It's not what you do after planting with your friends and your neighbors that your husband's trying to kill you. If you want to frame your husband, you don't delete it. But it is what you do when you're trying to clean up and cover your tracks. So finally, at the close here, let's talk about Julie Jensen's two greatest fears. Dr. Borman said in his testimony she didn't want to be labeled as crazy and she didn't want to lose her kids. With her death, Julie Jensen lost David and Douglas. And in death now, nearly 25 years later, she's labeled as crazy. We're having a whole trial on the topic of whether Julie's crazy. The tragedy of Julie Jensen, and there are many, is she can't escape gaslighting even in death after all this time. Because we're told that Julie apparently has this family history of depression that makes her a high risk for suicide, even though the actual evidence is that that history is so minor that it makes her family indistinguishable from thousands or perhaps even millions of other families. And that family history pales in comparison to the history of other families, like where there have been actual suicides. We're told that Julie Jensen is at a high risk for suicide, and I can hardly even begin to comment on the absurdity of Dr. West's testimony. But Dr. West said Julie Jensen's view of reality was distorted. The only thing that I saw that was distorted is Dr. West's view of the evidence. But one preposterous thing Dr. West said was how Julie showed signs of suicidality. Even though she'd never made a suicidal statement, she'd never shown any signs of suicidal ideation or a plan. She certainly never attempted suicide, even though Julie Jensen specifically denied being suicidal on December 1st. There's literally nothing, apparently, that Julie could have said to evade Dr. West's diagnosis of major depressive disorder. Nothing she could have said. And what about all these statements she made of fear? To Ted Voigt, to Margaret Voigt, to Therese DeFazio, to the defendant's own sister. We're told she's just so crazy. Too crazy to be believed. I mean, is she actively framing the defendant, or is she just so delusional that she thinks the defendant's trying to kill her? We're told that Julie used the internet, that she would use the internet, even though there's absolutely no proof of that. We saw how that internet usage mirrors the defendant's life, and there's nothing like that for Julie. Not a single example. Dr. Hale and Dr. Thomas, they tell you, they act as though Julie could have been on that computer, even after she got so sick the night of 12/2 and into the early morning of 12/3, and then finally at 9:42 a.m. on 12/3. even though that's contrary to the defendant's own words, the words of the defendant. And you know what? We're believing the defendant's words when he described Julie's condition, not just selectively because we want to believe those words because they're helpful to the state. We believe it and we know it's true because of David. The defendant knew David was talking about his mom and about her condition and about his last memories of his mother. The defendant knew the detective was talking to David. That's why there's all those weird statements in that interview. Well, David said. You can ask David. The defendant cannot lie about Julie's condition on the second and the third because David knows the truth. And then, finally, these doctors, Dr. Thomas in particular, they blame Julie. Why didn't she call for help? My goodness, if she was so afraid of being poisoned, why didn't she call for help? Well, why didn't the defendant? Julie had in her system ethylene glycol and Ambien and Librium and Paxil and Benadryl. She, a 115-pound woman, had 3 Ambien, a brand new drug for her, in 24 hours, less than 24 hours. And the defendant was there. He saw her condition. He was there the morning of the second, the night of the second, the day of the third. And he was there when Dr. Borman told him, if your wife's condition worsens, take her to the ER. And he was the one hearing David asking to take mom to the hospital when she couldn't speak. And somehow, according to the defense doctors, that's Julie's fault. That this woman on these 3 Ambien, sedated and drugged, it's her fault that she didn't call for help. It's like the more you get paid in this case, the less you can see the obvious. Julie's even blamed for Laura Koster leaving her job. Somehow that's Julie's fault. Julie's blamed for David's cough, David's tics, even though it was at her insistence that they scheduled that specialist appointment for David after those parent-teacher conferences. Dr. Borman testified they scheduled that specialist November 25th, but somehow that's still Julie's fault. Apparently everything, all ills can be blamed on Julie. Apparently she's crazy, and she's the one who was on that computer. But you know, it wasn't her whose hobby it was to create a stalker and invent years of terrorizing harassment using an array of pornographic photos. That wasn't Julie. And it wasn't her who took on the name of Warm Irish Eyes to catfish and torment a coworker. So let's go back to the evidence. At the time of her death, Julie Jensen was in a dilemma of the defendant's creation. And she described this to Therese DeFazio and to Ted Voigt. Either her husband was trying to kill her, to poison her, or he was trying to drive her crazy. Make her look crazy so in the divorce he could take the kids from her as he said he would do. And Julie was a smart person, but she didn't know what to do in that dilemma. And she couldn't do anything rash, anything that looked reckless or irrational. She had to make a plan. She had to leave in an orderly and rational fashion with the kids, but the defendant had been planning longer, and he executed his plan first. Let's look at him executing his plan. This, we see here two things that are the same. This is the picture that Julie Jensen took of the defendant's day planner and made sure she got it to the police. It says, withdrawn, kids, locked chest, crying about miscarriage. Next to that, the defendant's actual day planner. seized by the police. Same thing. Another example. A picture Julie Jensen took and gave to the police. Locked chest. Locked in bedroom, morning. Jobs quit, crying about miscarriage. Suddenly detached. Julie Jensen took that picture and gave it to the police, and we see the same thing in the defendant's day planner. That day planner, by the way, found right here, right by the computer, in that black bag, the defendant's day planner. This, what I've just showed you, this is gaslighting once again, and Julie saw it. Even if the police had made a mistake and not seized the defendant's day planner, even if that planner had not been seized, we would still have those photos. The police would have them because Julie gave it to them. And did Julie give those to the police to say, hey, police, look how crazy I am? Julie saw the defendant's plan. He wanted her to look crazy. She told this to Margaret Voigt, how the defendant was asking about this miscarriage, which was from years ago, and taking notes, and it made no sense to her. And she saw these notes, and she knew they weren't true, and wondered what the defendant was up to, and she made sure the police had it. Because Julie isn't crazy, it's just how the defendant wanted her to look. It's a continuation of the years of psychological warfare the defendant waged against his wife, but now the purpose was to make her look crazy so he could murder her, so he could give her a substance that would crystallize her from the inside out, a substance undetectable at autopsy, using a searches on the computer that he also thought would be undetectable once he deleted them. He thought he could trick Julie and the police, and honestly, if it ever came down to it, a jury. And if he hadn't made a few mistakes. Ed Klug, Aaron Dillard, David Thompson, the deleting of the internet history that wasn't deleted enough, maybe he would have been able to deceive and gaslight his way out of this too. Julie wasn't crazy. She was responding to the insane situation the defendant had orchestrated around her. If you look at the evidence in this case, if you look at the evidence, and if you aren't getting paid too much to see it, you'll believe Julie. You'll believe Julie when she said she was afraid, when she said she was afraid that the defendant was trying to kill her, when she said she saw the defendant looking things up on the computer, when she said he thought he was trying to poison her. You'll believe Julie when she said she wasn't suicidal, that she wouldn't do it. You'll believe Julie when she said her boys were everything to her, that she loved them, she didn't want to lose them, she would never leave them. You'll believe Julie, and you'll find the defendant guilty.
Folks, we'll take our break now. We'll talk about the case. We're getting real close, but go back and take your break, okay? For 10 minutes, thank you. We're back on the record on Mark D. Jensen, 2002, CF 314. The appearances are the same. The jury is back in the courtroom. We are the phase of the defendant's closing argument. Mr. Perry, you can start whenever you're ready.
Thank you, Judge. I want to say how grateful I am that I'm able to stand here and speak to you all after these last few weeks. Things have not been presented exactly chronologically, or I think in the easiest to understand manner. We've had video testimony. Sometimes that's felt out of order, out of chronological order. Sometimes it's hard to hear. It'd be hard for anyone to catch everything that's been presented. Myself, Ms. Krause, Ms. Renner, and most of all, Mark Jensen, are so relieved to have such an obviously attentive and serious group of jurors. So thank you for that. Now, I'm not going to yell and shout about penis pictures. I don't yell and shout about really anything. During this trial, we've tried to be measured and analytical. And that's how I'm going to try to approach this as well. Because this man is charged with homicide. And emotional appeals that cloud the relevant evidence is not what's needed. In thinking about all the things that have been presented and trying to organize it, the photos, the harassment, the penis drawings, that was a lot of it. How much of it is actually relevant to the prosecution's allegation that Mark Jensen committed first-degree intentional homicide? I think a lot of it is meaningless. A lot of it serves no purpose other than an attempt to establish that Mark Jensen had pornography in 2002 on his computer that the prosecution has a problem with. Throughout this time that I have, I'm going to try to focus on what Mark Jensen is actually charged with and the relevant evidence regarding it. You heard the judge read the instructions, and I just want to touch on one of those instructions. Because in America, when you're charged with a crime, you have no burden of proving your innocence. It's the government that has to prove it before you can be found guilty. That's because you can guarantee you won't commit a crime, but you can never guarantee you won't be accused of one. And you've heard this jury instruction of the level of proof that's required when you're accused of a crime, beyond a reasonable doubt. The jury instruction does a couple of things. First, it tells you what a reasonable doubt is, and then, in sort of a roundabout way, it tells you what beyond a reasonable doubt means. First, a reasonable doubt is, and you heard this, is a doubt based upon reason and common sense. The sort of doubt that would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. Pause or hesitate when called to act upon the most important affairs in life. What are the most important affairs of life? Is it buying a house? Is it choosing whether to trust somebody? Is it buying a car? If you're buying a house, at the home inspection you see a hairline crack in the foundation, do you pause or hesitate to have to need more information before you move forward? Because if you do, that's reasonable doubt. That's the standard in Wisconsin. And that instruction about the level of proof that the prosecution bears in this case before you can be convicted of a crime. What if you find out that your home inspector has a fraud conviction? Do you pause? So that's reasonable doubt. But what does beyond a reasonable doubt mean? First of all, it means nothing has given you any pause. But the instruction actually tells us what beyond a reasonable doubt means. It says you are not to search for doubt, you're to search for the truth. And that makes sense. Because if you were to search for doubt, that would mean the defense carries some sort of burden. And we know that's not true. The entire burden is on the prosecution. It's the truth. Has the prosecution proven its case such that you're convinced its allegation is the actual truth? Because if there's something that gives you any pause or hesitation when considering the prosecution's allegation of what, when, where, why, how, that's reasonable doubt. And it's only when you can comfortably say there's no pause or hesitation that you can say that the prosecution has proven its allegation to be the truth. It's not guessing. It's not guessing at what you think may have happened. It's a careful analysis of whether the government has met its very high burden before a person in America can be convicted of a crime. Through the course of my time to talk with you, I want to talk about memory and how we all know how memories change. How they changed in this case, you saw that with witnesses testifying now, asked about their memories and what they testified to in 2008 and 2007, in 1998, maybe in 2002 when they were first interviewed by the investigators. How it was years before investigation even spoke to people in this case. How it was 9 years before some people even claimed they remembered anything. This trial has taken about 3 weeks. Wait and see when you go into deliberations if you all have the same memory of what each witness said. I want to talk about lies, because the centerpiece of the state's entire prosecution is a lie. And I want to talk about something called confirmation bias. Confirmation bias is when someone searches for and interprets information in a way that confirms or supports one's belief. It's not scientific. It's the opposite of scientific. It's not a process that results in a fair assessment of evidence. It's the opposite of fair. We see it in the states bending facts to science when it should be applying science to the facts. We see it in how Julie Jensen is described by the state. We see it in the systematic ignoring or pretending that certain facts just don't exist. We talked about things that cause you to pause or hesitate in the most important affairs of life. These are things that can cause more than just a pause. These are full stops. I want to mention a couple of things just out of the gate. There have been some, and this fits with what I've just talked about. There's this assertion that there's a high five when Mark came back to his house on December 4th. We talked with Detective Ratsberg at length about the handoff of that house on December 4th and the police that were there and all the observations of Mark Jensen. And you didn't hear anything about an observation of a high five and the timing of when this would have happened and it being late at night and how everything was being observed and recorded. This idea that Mark Jensen threw away her belongings. Now, I mean, I'm not going to be able to go through everything everyone said, and you're going to have to rely on your notes for some of these things. But the throwing away the belongings, when we dug into what does that mean, what was actually observed, very little. And very little knowledge or no knowledge at all about whether things were set out for a donation, what was in bags. Somebody recognized something that they thought may have belonged to Julie Jensen, and from that, this memory was created that, oh my God, Mark Jensen threw away all of Julie Jensen's things. Go back and look at what was actually said about that. He hated her, and that's what was going on. I mean, that's really, I'd say it's a lot more complicated. We heard just yesterday how Mark and his son were building a Christmas rod, a fishing rod for Christmas for Julie Jensen. Those day planner notes, and then combined with her later statements about how he's encouraging her to see a doctor. The investigation that was done in this case, even the things found in that office, the box of zip drives, nothing was fingerprinted. This theory, this idea that Julie Jensen never had anything to do with the computer. There's just very little investigation that was done in most of these things. They weren't looking for ethylene glycol. This idea that it was hidden, or what was Mark Jensen doing on December 3rd? They weren't looking for ethylene glycol when they searched the house. Detective Ratsberg acknowledged that. He said, when we looked back at the video, yeah, I could see things in the garage that looked like probably antifreeze. They took the Playboys. They didn't take the antifreeze. I need to spend some time talking about Aaron Dillard. Aaron Dillard, Aaron Galvin, Kyle Rezick. I don't know who this person is. He's an actual con man. He's someone who has conned educated people out of their life's savings. He's an international con man. And he's never stopped his lying, and he's never stopped his deceit. How does a con man convince people to buy his stories? He blends facts with fiction so that it sounds possible. He tells people what they want to hear. He presents himself as a reasonable, well-spoken individual. I think you saw that in here. You saw how he presents himself. In Lithuania, these families wanted visas to America, so Aaron Dillard took their life savings, and he did that 7 times over. Think of the things that Aaron Dillard was willing to do for a few $100s or a few $1,000s. He lied about who he was. He defrauded companies. He bought check stock, created false companies, false payroll checks. He researched how to be a medical and surgical equipment seller in order to defraud Wendy Reamer, who believed his name was Kyle Rezick, over and over again. You heard Lori Brown. She was a lawyer and then an administrator of a law firm, a smart, educated woman. She got defrauded by Dillard. She described him as personable, knowledgeable, and that he instilled a lot of confidence. Her opinion? He's not a truthful or honest person. How about Deborah Teagle Spears? She testified in this case. She met Kyle Rezick. She lent him money. Eventually, she went into his wallet to find out what his real name is and ran a check on him. Do you remember what Miss Spears said about Dillard when asked about his character for truthfulness? She said, he has no character. He's a con man. He uses people for what he can get out of them. So on August 14th, 2007, when Aaron Dillard got to the Kenosha County Jail, what was he willing to do? He had been out on extended supervision and was coming back to court to determine how long he was going to go back to prison. He was AWOL from supervision. He got pulled over on May 31st, 2007. At that point, he hadn't reported to his agent since the previous October. When he got pulled over and he had a suspended registration, he lied to a police officer and said he was his brother, Mike Kaiser. And then while claiming to be Michael Kaiser, he blamed the suspended registration on his brother, Aaron Dillard. This is what he does. The police figured it out and he got charged with obstructing an officer. He had 17 violations while out on probation. He had cheated Dennis Ritt out of money. He told Dennis Ritt that he had a telecommunications company in Lithuania. He convinced him to lend him money, never paid him back. He wrote a check from a closed bank account to Dennis Ritt, knowing it's not good. He had defrauded Lori Brown. He had defrauded Cassandra Ivey. Cassandra Ivey had paid him $6,200 and had a construction contract with Dillard. For that, he got charged with theft by contractor and home improvement fraud. Dillard was facing 7 years on that case. For the reconfinement, he knew that his probation agent was recommending he get the maximum time available of 4.5 years. And it was an aggressive recommendation. I asked Aaron Dillard this when he was testifying, and he acknowledged, he said he was aware of the probation agent's justification for the maximum sentence. And I read it to him, and he remembered it. It is obvious that Mr. Dillard is in need of serious CGIP, but his criminal behavior is well beyond the need of cognitive thinking. His repetitive, deviant thinking is just in plain need of confinement. Even though prisons are normally used for rehabilitative purposes, Mr. Dillard is in desperate need of incarceration. It is the suggestion of this document that persons with criminal behavior of this caliber show no guilt or remorse. Their goal in life is to be a successful criminal. They are motivated by the power they feel to manipulate others, sometimes for material gain. So when he got to the Kenosha jail on August 14th, 2007, he was facing 9 months on that obstructing charge, 7 years on the theft by contractor home improvement fraud case, and a recommendation of 4.5 years from his probation agent. What was Aaron Dillard willing to do for a few $1,000s? Ruin people's lives. And you've seen what Aaron Dillard was willing to do to get out of years of prison. When Aaron Dillard got to the Kenosha jail on August 14th, 2007, he immediately recognized Mark Jensen. He knew about him from articles, he knew it was a high-profile case, and within 30 minutes he was talking with him. That's how quickly Aaron Dillard found his mark. And what did Dillard claim? He basically talked nonstop with Mark Jensen about his case. The evening of the 14th, all day on the 15th, all day on the 16th. He said that Mark Jensen shared the transcript of the Klug hearing and then talked all about his case. He said that Mark protested his innocence all evening of the 14th. He said that Mark protested his innocence all day on the 15th. And then on the 16th, Aaron Dillard said, you know, we all did something to get here. And Mark said, yeah, and then gave him a full confession. Do you remember the 7-hour interrogation by Detective Ratsberg? You were shown 45 minutes of it. Highly trained interrogator. I guess if only Detective Ratsberg had said, come on, right? Aside from just how unbelievable this story is, the prosecution bought it completely. Dr. Mainland bought it. Dr. Chambliss bought it. Mark Jensen was charged in 2002 with homicide in this case. Then in 2008, after hearing about Aaron Dillard's claim, they changed their opinions. Dr. Chambliss went from undetermined to asphyxia by smothering. Dr. Mainland went from ethylene glycol poisoning to ethylene glycol poisoning with probable terminal asphyxia. Why was everyone so willing to be victimized by Aaron Dillard? I think it's because the science and the evidence don't support the theory that Mark Jensen killed Julie Jensen with ethylene glycol. I think it's because it makes no sense that if Julie Jensen was paranoid and not eating or drinking anything from Mark, that then she'd suddenly eat and drink everything he gave her. And according to Doctors Chambliss, Mainland, and the prosecution, where could Aaron Dillard have learned these details? We're not wondering that anymore, are we? On August 11th, 2007, 3 days before Aaron Dillard showed up, Mark Jensen received 2 oversized envelopes from his attorney. In those envelopes were the transcripts of Ed Klug and the interrogation of Mark by Detective Ratsberg. Now, you heard from Nathaniel Clanton. Nathaniel Clanton's time in J Block actually overlapped a little with Aaron Dillard. I think he said he got there on August 16th. Nathaniel Clanton explained how Mark Jensen handled himself in the jail. He said Mark had 2 bins of paperwork. Mark would freely discuss details and share that paperwork with other inmates. He'd share his police reports. He'd freely share his case files. Nathaniel Clanton explained that Mark would even share this with the people that were only there for a few days. And Nathaniel Clanton did more than that. He explained what an awful idea it is to share your information in a jail. People will use it against you. They'll take the information, they'll twist it, they'll add some lies, and they'll make it look like you're confessing to something you didn't do. Mr. Clanton explained that happens quite a bit in jails. When Detective Ratsberg interrogated Mark Jensen, he told you that he was trying to come up with different scenarios to get Mark to confess. Detective Ratsberg had the autopsy, and he was trying to make his scenarios fit what he thought were the autopsy findings. He testified to that. You heard Detective Ratsberg's imagined scenarios that he proposed to Mark Jensen. Her arm was actually here. I'll show you how she was, okay? Her arm is actually across her body like that, okay? And it's an unnatural position. Do you sleep when you're on your side with your arm across like that? I know there was some type of contact there. There had to be in the chest, this chest area, Mark. There's no question about that. And the only person that could have done that was you. I'm thinking before you left, you pushed on her maybe. Now, she was frail at the time. She was frail. You said she was labored breathing. That makes sense, and I believe that. Okay, I know that probably happened, but she's frail. And you just innocently, I don't want to, pushed her like that. And could that have caused something? I mean, we have petechiae of the lungs. There's some type of contact here in the throat. There's also been an indication on the throat, as I showed you in Dr. Chambliss's report. It just did not appear there. Something and somebody had to touch her. That's the only way it could get there. There's no doubt about that. And did you push her, touch her on the throat maybe? Maybe like this? Maybe when you brought her over this way, you pushed her back on the chest and then went back and brought her up again. You know, you would have pushed her back. We still have to explain the nose part, the head pushed into the pillow. How are we going to explain that? I mean, that's there. Something had to push it down. There's three things that happened here. Head being pushed, the nose, some type of contact here at the throat, and some type of contact here in the chest. We know that happened, okay? You were the only one there. You had to do something, Mark. Dr. Mainland acknowledged, testifying this time, that Aaron Dillard could have gotten those details that made up his claim from this transcript. She agreed that Aaron Dillard's claim was not found in the Klug transcript, but was found in Detective Ratsberg's claims in the interrogation transcript, and that those claims lined up with the autopsy report. The prosecution has insisted, though. I keep insisting. Aaron Dillard denied reading anything except for the Klug transcript. Well, his claim would be a lot less convincing if he admitted to making it up. Can you trust what Aaron Dillard says when a decade of prison is on the line? Can you trust him when $50 is on the line? Dr. Mainland said she wouldn't buy a used car from Aaron Dillard. Does Aaron Dillard give you pause? To me, it warrants slamming on the brakes and never wanting to engage with the man in any way. We have to look further because his story has some reveals. Look closely at it. He said that Mark wishes he hadn't opened his stupid mouth around his coworker about him wanting to kill his wife. That's what's fucking him now. That's what Aaron Dillard wrote. So the person who allegedly regrets saying something to Ed Klug while maintaining his innocence, while denying that he ever said anything to Ed Klug, would then open his mouth and offer a full confession to the person that you're saying these things to? That doesn't make any sense. Aaron Dillard says, on a Tuesday, he took her to a doctor. That's a small detail buried in his statement. But we know from Dr. Borman that Julie came alone to that doctor appointment. He first describes Julie Jensen on December 2nd as just throwing up a little. He then changes it to really just vomiting. There's no vomit anywhere. And when she died, her stomach was full. He says that Mark came home and that Julie Jensen was breathing better. But we learned from Dr. Hale, the only one who testified in this courtroom that was qualified to discuss ethylene glycol poisoning, the only toxicologist you heard from. As long as a person is still processing ethylene glycol, they'd be in phase 2. Their breathing wouldn't get better. They'd be trying to get rid of that, to blow off that carbon dioxide. And because Detective Ratsberg isn't a forensic pathologist, he proposed an asphyxiation death, but didn't take into account that there were no marks or injuries to the inside of Julie Jensen's mouth when what's described is shoving her face into a pillow until she asphyxiated. He didn't take into account that nothing was aspirated, nothing was regurgitated, There were no injuries on her back. Would you buy a used car from Aaron Dillard? His story is a lie meant only to benefit himself. When he created his story, he had over a decade of prison that he used this to reduce to 0. Now, he's got even more at stake. He's facing decades in prison right now, and he's getting another letter from the prosecutor, which is the same thing he got in 2008, resulting in no time for lying to that officer. Would you rely on Aaron Dillard for anything except to lie? I want to talk about the autopsy. Dr. Michael Chambliss wasn't the medical examiner for Kenosha County. He came down on December 4th to do the autopsy. He did his autopsy report, and then he did nothing else with the case. He didn't review reports. He didn't send things out for studies. I think he said he didn't even review the toxicological results. He did an autopsy, and then he turned it all over to the medical examiner's office, and his role was done. That autopsy was in 1998. I think the faxed autopsy report was in February of 1999. The person he turned it all over to, Dr. Maureen Lavin, we never heard from her in this trial. A side note, even though Dr. Chambliss, even though the only report he ever did said that the cause of death was undetermined, he felt pretty comfortable in court giving an opinion to cause and manner of death without having done that investigation that a medical examiner does. Do you remember Dr. Lindsay Thomas testifying? The renowned and respected forensic pathologist? The prosecution attacked her because she didn't know the acronyms Mark Jensen and Kelly Labonte used in their emails. But Dr. Chambliss, he told you that his involvement in this case and his investigation was done at the time he issued that preliminary report. So what did he note and how did he explain it? He agreed that Julie Jensen had a substantial amount in her stomach. He agreed there was no way of knowing how long it was in there. It was very likely she had delayed gastric emptying. He identified petechiae in the cardio area. He found no injuries to the insides of Julie Jensen's lips and cheeks. He found no fluid in the nose. There was no aspirated food in the respiratory system. He found zero evidence of external forces to the chest. He found zero evidence of trauma to the abdomen. There were no rib fractures. And then he identified a small amount of hemorrhage involving the soft tissues and muscles attached to the left, second, third, and fourth ribs. Remember this theory that exists that from Aaron Dillard that this grown man climbed on top of Julie Jensen's back and forced her lungs to close. Set aside whether the evidence actually established that this hemorrhage was just post-mortem lividity or congestion since Julie Jensen was lying on her side. And set aside for a moment that the picture actually just shows darkness on all the ribs on that side of the body, demonstrating that this is just congestion. Dr. Chambliss even said this could be post-mortem artifact. He testified he doesn't know when this injury, if it even is an injury, even occurred. He said it could have been caused by bumping into something. And then he was asked whether Julie Jensen's death could have been positional asphyxia, whether she had gotten herself into a position and she couldn't breathe. And he said no. And the reason he said no is he said, because that wouldn't explain the hemorrhage on the ribs. This is the very thing he just had testified could have been caused by bumping into something, could have been post-mortem artifact. And if it was a hemorrhage, he was unable to say when it occurred. But then the reason he rejected the idea that Julie Jensen might have gotten herself into a tough breathing position is that it didn't explain the very thing he agreed had several completely innocent explanations for. I don't know what to do with that. That's confirmation bias. That's some sort of circular logic that does not belong in a courtroom. That's wholesale reliance on Aaron Dillard. Even with that, then Dr. Chambliss agreed that if Aaron Dillard's a liar, then Dr. Chambliss's cause and manner of death would be undetermined. Science didn't lead to Dr. Chambliss's opinions. He made the science fit the story told by Aaron Dillard. Dr. Mainland also, she says, that could be hemorrhage, it could be congestion, I don't know what it's from, when it's from, could be post-mortem artifact. After Aaron Dillard, it's hemorrhage, it's terminal asphyxia. She said she wouldn't buy a used car from Aaron Dillard. I'm sorry, but that says all you need to know about how Dr. Mainland's use of the phrase to a reasonable degree of medical certainty. In its opening statement, the state called Kelly Labonte the motive. Excuse me. Throughout this case, how many times did we hear about the cruise they were planning? At some point, she described to Mark Jensen all the men she had ever been with. And yesterday, when Mr. Jamboys was cross-examining Dr. Sarah West, he argued these four things. He said, Mark Jensen and Kelly Labonte had an affair, and they had made a plan to go on a cruise in 1999. Kelly Labonte then divorced her husband. Then Julie Jensen died. Isn't that convenient? Do you remember those questions? Well, the problem is the chronology is completely off. They had an affair. No one's contesting that. Julie Jensen had an affair. Mark Jensen had an affair. I'm not saying that makes them even or something, but these affairs happened, and it's not being contested by us at one bit. Kelly Labonte talked about divorce. And then Kelly Labonte called off the affair with Mark Jensen. And buried in all the emails that were presented in this case, on October 27th, 1998, Kelly Labonte says, I did realize I need to give this a fair shot or get the hell out. I've decided to give it a fair shot first. A 6-year relationship that I fought tooth and nail for and a 1-month marriage deserves at least one bold effort. Anyway, I would very much like your support on this. I need to focus on the positives of this marriage and see what happens. Mark's response? You've always got my support. That was October 27th, 1998. Kelly Labonte called off the affair in October. She ultimately left her husband. That was in January of 1999. and then she got divorced in March or April of 1999. So this argument, how convenient for Mark Jensen that Julie Jensen died after this divorce from Kelly Labonte with her husband, it's changing the facts to fit the narrative. It's clear that this marriage was in trouble well before Mark Jensen had his affair. This marriage was in so much trouble that when Julie Jensen had her affair, she actually filed for divorce in 1991. I want to talk about Ed Klug. Think of how unbelievable Ed Klug's testimony is. How unbelievable he is as a person. The Blueprint Conference was in November of 1998. Julie Jensen died a month later. Over 3 years went by, and he reached out to the police department because he had something to say. And what did he have to say? That Mark might have used a computer in the Appleton office, but all the computers have since been changed out. That's it. That was his contribution. And nobody cared. 5 more years went by, and we're now 9 years from when Julie Jensen died, and Ed Klug gets contacted. And Ed Klug suddenly has a much more interesting story for the prosecutors. You know what? A month before Julie Jensen died, Mark Jensen told Ed Klug, someone he did not have a personal relationship with, that he was looking up ways to kill his wife. Now, in 2007, he had no notes of this. He testified he didn't have notes of this. He testified he didn't write anything down. He had no notes of any conversations or any details. In 2008, he found the notes. This is one of them. They don't say the words ethylene glycol or antifreeze, but that's what he remembers, Mark told him. Why didn't Ed Klug come forward? He says it's because Mark was his boss. But Mark wasn't his boss in 2002 when he reached out to the police to tell them that Mark had used a computer. Ed Klug testified that when he called his wife at 2:34 a.m., he told her that Mark Jensen was talking about killing his wife. According to this note and to his story, Dawn Cooper was present. Near the bottom, Mark unloaded on us. So what did Dawn Cooper say? She remembered sitting with Ed Klug and Mark Jensen in the hotel lobby after bar closing. She was going through a divorce, and they were saying supportive things to her. She remembered Ed Klug leaving to call his wife. She said there was no conversation about harming wives. She said there was no conversation about anyone using a computer to look up ways to harm a wife. She was no longer working at Stifel in 2002 when Mark got charged in this case. She testified she got a call from Ed Klug, and he said nothing about any conversation in 1998. Dawn Cooper got contacted by the prosecutors in 2007, or by the investigation. And the way she was asked about it is consistent with what Ed Klug says, that she would have been present for that conversation. And she knows it never happened. She would have remembered that. Stacy Bauer, she worked in the Appleton office. She came here and made an assertion that she heard this from Ed Klug. She also acknowledged having read about Ed Klug's testimony. And remember this, what's on the screen? That's her written statement from August 10th of 2007, which says, quote, "I have no knowledge of a conversation Mark had with Ed Klug in St. Louis regarding killing his wife," end quote. Ed Klug says that Mark was talking about a website called howtokillyourwife.com. In all the computer stuff that we've heard, have we heard anything about howtokillyourwife.com? Joan Wise was Ed Klug's longtime assistant. Do you remember that Ed Klug claimed he told all staff on the Monday after the conference about this conversation? Joan Wise says that never happened. She never heard anything about Mark Jensen from Ed Klug, except that Mark Jensen's wife had died and that she had committed suicide. That's what she heard from Ed Klug. Ed Klug never said that Mark Jensen talked about killing his wife. She gave us her opinion about Ed Klug's honesty. He's not a truthful person. Her knowledge about his reputation, you can't believe a word he says. He's an attention seeker. Ed Klug's testimony about his drunken night in 1998 is just not believable. Ed Klug is not believable. This issue of David Thompson, David Thompson acknowledged that prior to talking to Mark Jensen, he wrote a letter to his fiancée saying, "It's time to help myself." And everything about David Thompson is consistent with this, that David Thompson came up with a proposal, a crazy proposal, that somebody would be held for 6 weeks for $1,000, that he communicated that proposal to Mark Jensen, and then it's also very clear that no money ever exchanged hands. Now, you heard some phone calls. You heard some recorded phone calls between Mark and his parents. And the one that I had played, the couple that I had played, predated the ones that he was calling, where it was a three-way call with David Thompson. And you can hear the intimidation in Mark's voice. And he's talking about, "I need you to do this or I'm going to have a fight on my hands." You heard that advice from Nathaniel Clanton. Nathaniel Clanton said, "This would be the dumbest thing you've ever done," or something like that. And he said, "Beat your case fair and square." It seems like Mark took that advice because no money ever changed hands. There's this sort of peripheral theory that's been floating around in this trial, that in November of 1998, Mark Jensen had tried to kill Julie Jensen with ethylene glycol. And the only reason that this exists is because of Aaron Dillard. Now, we know that Julie Jensen threw up all over the carpet and didn't clean it up. And we've heard all about what ethylene glycol poisoning is. We didn't hear really about it from the state's witnesses. Like I mentioned earlier, no toxicologist. Their experts were Dr. Chambliss, who didn't review things, and then Dr. Mainland. But here's what's interesting about this claim, is Julie Jensen was at home with the kids. And with all the conversations and reports to the neighbors, the Voights, and with all the phone calls to Dr. Borman when there was the slightest sickness in that household, and with the statements about the paranoid statements about maybe being poisoned or being drugged or somebody's out to get me. There's nothing about this incident. There are no reports to Dr. Borman. There's no reports to the Voights. There's no report of breathing problems. There's no report of intoxication. There was no poisoning in November. I'd suggest that this vomit all over the carpet that wasn't cleaned up, that might be indicative of something else that was going on. Julie Jensen used the computer and she used the internet. We know this from Laura Koster. Laura Koster was an IT expert. She said that Julie Jensen used the computer and used the internet. We know this from her son, David Jensen. We know this from the Quicken software that she used when Mark was out of town. We know this from the resume she created on the computer. There's this statement from Therese DeFazio that Julie Jensen said she didn't know how to turn on a computer. And then there's a little bit more of an explanation. And Therese DeFazio talked about clearing out the cache or checking the cache. And the clarification is that Therese DeFazio, at school, they had Macs. Could that have been why Julie Jensen didn't know how to turn on the computer at school? Because at home, they weren't on just their first computer, and they had IBMs. Now, set aside the problems with the investigation. The computer wasn't write-blocked when Detective Ratsburg insisted it be turned on, and the corruption of the files that can be caused by that. Now, the state said, when they looked through these different websites, they said, we know it was Mark on some days because the website was for Bass Pro Shops and for a cruise. They looked to context to say who would have been on these sites, who would have been looking at these pages. Well, the interests of Julie's and the context of these websites tells us what was going on. This October 16th, the recipe link, a message board for cooking recipes, botulism. Who was the only one who did any cooking in the Jensen household? On October 16th, after 11 p.m., there's an access to the Stifel branch listings. And an email between Mark and Kelly Labonte from earlier that day. And then there's a search in Stifel for a Kelly, no last name. Mark Jensen knew who Kelly Labonte was, and he knew how to email her, and he knew where she worked. Julie Jensen knew who Kelly Labonte was. She knew of Kelly Labonte. This is the cover. This is the first page of Julie Jensen's day planner. And you see on the upper right corner, it says Kelly Labonte. And this lines up with what Ted Voigt said, that about 5-ish weeks before her death, that Julie Jensen knew that that Mark was having an affair. The prosecution needs this to be Mark Jensen because there are searches for mercury fulminate and nicotine. The prosecution needs it to be Mark Jensen, or else it shows that Julie Jensen accessed the computer late at night. On November 10th, 1998, suicide message boards. A search for suicide, a search for physician-assisted suicide. I don't know why anyone clicks on different links after doing a search. I don't know how long Julie Jensen stayed on the page of physician-assisted suicide, but there's only one person in that house that would have been searching for suicide with what we know about the context of what was going on with Julie Jensen in those last couple of months. Look at the internet searches on December 2nd that Ms. McNeil showed you. 8:16 a.m. through 8:38 a.m. An article on ethylene glycol poisoning, oxalic acid, fomepizole, toxic alcohols, a page on how patients with toxic alcohols present, the dangers of ethanol substitutes, ethylene glycol, specific poisoning information. We heard about SSRIs from Dr. Hale, I think, and also Dr. West about the risk of certain medications and how they can ironically increase somebody's risk at suicide. The prosecution needs this to be Mark. But on December 2nd in the morning, Mark took Douglas to daycare. That was at 8 a.m. And then he went to Dr. Borman's. And after meeting with Dr. Borman, a prescription was written, and Mark Jensen took that prescription to Walgreens, where he waited for it to be filled. That was around 11:13 a.m. These searches at 8:16 a.m. to 8:38 a.m., all about ethylene glycol, it had to be Julie. On December 3rd, you have searches late at night and then in the morning. 9:40 a.m., toxic alcohols, ethylene glycol poisoning. A page on diabetic ketoacidosis. 9:42 p.m., 2 minutes later, back to the Yahoo search results for ethylene glycol poisoning. I think it was the state's first two witnesses in this case, Ruth Vorwald and Shannon Krause. 9:30-ish, they saw Mark driving. He wasn't at home. These had to be Julie. Mark had gone to pick up a check from a client. Then later he said that he stopped in the office. Now, Detective Ratsburg waited over 3 years to interview anyone at the office. And 3 years later, after Mark had been charged, they said they didn't see him that day. Well, the police searched all of Mark's property. They searched his briefcase, they searched his office. The check that he went and picked up from the client, that wasn't found at the house. This is the problem with memory. It's the problem with waiting years to talk to people. Now, we know from Dr. Hale about the late stages of ethylene glycol poisoning. There is no scientific reason that she would have been unable to go to the office and do a basic internet search. We know her body was producing urine, and there was no urine or any fluid in the bed. Julie Jensen was able to get up and go to the bathroom. We know from David Jensen that his mom hugged him and spoke with him that morning. You know what's interesting is there are no searches on this computer for Ambien, Paxil, Librium, there is paroxetine, Librium, Benadryl. No searches for divorce, right? That point's been made. Even though we know Julie Jensen was planning on getting a divorce. We heard that yesterday, that after the holidays, she'd be getting a divorce. Nothing like ethylene glycol or poisons or drug interactions were ever found on Mark's work computer. And this claim that he fried that computer is nonsense. They recovered that computer and they analyzed it. So, who was Julie Jensen? We heard from witnesses that Julie Jensen was a lovely human being. We heard from witnesses that she was a devoted mother. We have no reason to doubt either of those characteristics. But you can be lovely and you can be devoted to your kids and you can be mentally ill. And Julie Jensen was mentally ill. She had a major depressive disorder and was at high risk of suicide. Sometimes it's hard to put a finger on what we're supposed to believe about Julie Jensen. Was she meek and vulnerable? Did she need Mark's permission to discuss their kids' medical issues with a doctor? Was she constantly under the thumb of her husband, being controlled by whatever he wanted? Was she so naive that in 1998 on their second home computer that she didn't know how to turn one on? Did she need Mark to explain to her why she was feeling intoxicated on December 2nd? It sure doesn't seem that way. She was a straight-A student. Chemistry, human physiology, death and dying, pharmacology, psych abnormal behavior, genetics. Those transcripts were admitted into evidence. She had her Series 7 brokerage license. She created a resume. After she had her own affair in the Jensen home with their 1-year-old in the house, she was the one who sent Perry Tarika packing and told him never to call or contact her anymore. That's not meek. We heard about her counseling in 1990 to 1991 with Paul DeFazio. She decided she wasn't happy with the progress. It wasn't going fast enough. And so she called and said she was going a different direction. That's not meek. When she fell in love with Perry Tarika, she got a lawyer and filed for divorce. She was in charge of the family finances. You've heard how she used Quicken on the computer. Her best friend, Laura Koster, the IT specialist. Laura Koster looked to her for how to use Quicken. Laura Koster confirmed that Julie Jensen used the computer and used the internet. When the private investigator, Dave Ellis, when he told her that the photos left at the house weren't her, she told him he was wrong. And she told him she didn't want his services anymore. When Perry Tarika sent her a letter with clipped out articles and cartoons, Julie Jensen called the police on him. Julie Jensen made decisions for herself. Now, the prosecution has advanced this theory that Julie Jensen was made to believe she'd lose the kids if they got divorced. I don't know where that claim comes from. She had a lawyer when she filed for divorce in 1991. She asked for full custody in that filing. According to Jill Polera, she was about to file for divorce again. Laura Koster said Julie didn't need Mark's permission and didn't need Mark to tell her what to do. Laura Koster would go to Julie Jensen with medical questions. But Julie Jensen did have some serious, long-standing mental health problems. And here is where I think the photos and the phone calls are actually relevant. We know that on June 29th, 1990, Mr. DeFazio, the psychotherapist, met with Julie Jensen. She had a new son. She'd been married for 6 years. He identified the possibility of limited postpartum depression. She described her mom's problem with alcoholism and said that there was a family history of depression. Mr. DeFazio testified that Julie Jensen was experiencing some obvious mental health issues. He diagnosed her as adult situational reactive with mixed features. He noted features of depression and anxiety. She told him she had a very unhappy childhood and was not happy whatsoever. Now, in July of 1990, she described getting little support from her spouse at home. In September of 1990, seasonal depression was noted. 2 weeks after that, they discussed an antidepressant and he referred her to a psychiatrist. She was prescribed Prozac. The psychiatrist, Dr. Newman, described her as crying all the time, having no appetite. She used to enjoy cooking, and now it's just a chore. Those are the notes. Chronically depressed, cries easily. Mr. DeFazio explained that with depression, things that used to give pleasure just don't anymore. Now, I mentioned in June of 1991, Julie Jensen canceled and said she wanted a different therapist, that progress wasn't going fast enough. She never told Mr. DeFazio about the affair. Mr. DeFazio made no referrals and did not know if she saw anyone else. Now, throughout this time are the hang-up calls and the issues with photos left at the house. I don't know what to make of the hang-up calls. Her log lists a lot of them. There's this narrative from the prosecution that it was Mark, and that when there'd be a trace, the calls would stop. We've heard that. It's false. We looked at the logs. We went through this. The vast majority of the hang-up calls were out of area. And in the 90s, I guess they couldn't trace those. The calls kept coming in while the traces were in effect. We've seen that in the logs. I went through those with Detective Ratsberg. Detective Ratsberg testified that out of area meant out of state. Mark's work phone was a 262 area code. The prosecution's argument that Mark was gaslighting Julie with hang-up calls, we know that because of the traces, is just simply false. The less than thorough investigation of Perry Tarica as being the source of the calls, they called and asked him and he said it wasn't him. Were these just normal hang-up calls? If they were, was this just more paranoia and perceived harassment? So what about these photos? Perhaps we can consider what evidence there actually is about these photos. What was actually described in all of those police reports to the House? The reported leaving of photos was sporadic. And Julie Jensen was convinced it was her in the photos. What Detective Ratsberg wrote, when I spoke with Julie last, she mentioned to me that she and Mark had sexual problems, and she stated that the photos, which normally showed her having contact with a man's penis, is something Mark wanted to do, but she refused. The photos were described as showing her. They were described by Julie Jensen as showing her. Now, Julie Jensen was a smart person and presumably would know if these pictures were of her. Now, despite testimony that there was a bag of evidence turned over and all the photos. All that was retained was a single photograph that by its description was unlike any of the others. This one was on actual photo paper. It had, I think, like a Kodak stamp on the back, and the picture looked nothing like Julie Jensen. Maybe the other ones didn't look anything like Julie Jensen, but the other ones were described as being on copy paper. These were never fingerprinted, although Detective Ratsburg acknowledged that they could have been. We heard from the secretaries that worked with Mark in 1998. They denied opening any mail that had pornographic pictures. But Detective Ratsburg confirmed that the only claims about getting photos in the mail at work were in the early 90s. Here's what else we know. They were all destroyed. So these pictures that Mark Jensen is accused of leaving around and sadistically torturing Julie Jensen with, there's no evidence for us to look at. Now, Mr. Jamboys asked Dr. West yesterday. He asked her this question. If Julie Jensen knew that she was being sadistically, psychologically tortured by Mark Jensen, would that suggest that her perceptions of reality in her stated fears were not distorted? First, Julie Jensen consistently denied everyone's suggestions that it might be Mark leaving the photos. She fired Dave Ellis, the investigator, when he made that suggestion. She insisted to Officer Kosman that they were her. So, if it was truly obvious that these pictures weren't of her, what does that say about her mental state that she just insisted that they were? Now, the next doctor reports that we have are Dr. Borman's. And he was her doctor from the mid-90s until Julie Jensen died. And she called about so many things. She called when Mark Jensen had washable marker on his face. She called if there was a cough in the family. You heard us go through these records. But in September of 1998, at that appointment, she brought up the family history of depression. She was concerned about her mom's history. She was tired. She had been prescribed Prozac before. Dr. Borman diagnosed her as having mild depression. At that visit, she weighed 123.5 pounds. In the fall, Laura Koster was talking with Julie Jensen outside while the kids played around them. And Julie showed Laura a photo of a list and a plastic syringe and asked her what she thought. And to Laura Koster, the person who knew her best and was her best friend, nothing seemed odd about what she was being shown. But what she noticed from this was the unsureness and the oddness of the question. And then Julie, while the kids were playing around them in the driveway, mentioned she thought Mark was going to kill her. And Laura Koster told her she didn't see it at all and was absolutely stunned by the suggestion. But she said, "If you feel you're in danger, come with me and we'll make sure you're safe." Laura Koster knew Julie Jensen better than anyone, and she said that Julie Jensen wasn't scared. She said Julie Jensen, in that conversation, had extraordinarily flat emotion for the topic of that conversation. You heard about on November 29th, there's a search for antifreeze. And then on November 30th, Julie was at karate practice and talked with Laura Koster again. This is the week that Douglas was starting full-time daycare. And Julie said she'd be going to see a doctor and be treated for depression. That she was going to see a doctor that week and be treated for depression. And then she said she wasn't going to be at karate for the next few days or at the next time. She said Laura wouldn't be seeing her for a few days. Laura described her as unusually emotive, that Julie Jensen hugged her and it was like a goodbye. And then Dr. Borman saw her on December 1st, 1998. He fit her in. She was alone at that appointment. Dr. Borman explained that Julie really didn't want to be labeled as crazy. She was miserable. She was depressed. She had decreased appetite. She had lost nearly 7% of her body weight from the previous visit. She denied any issues of domestic violence. She was distraught and in tears. She declined counseling. She denied being suicidal. She denied being homicidal. Dr. Borman had never seen her like this. On December 2nd, Mark Jensen came and expressed his concern about Julie's sleep issues, and Dr. Borman gave him a prescription for some Ambien. Now, the prosecution seems incredulous that Dr. West thought that the prescription of Ambien was not based solely on the word of Mark Jensen. She opined it was necessarily filtered through the information from Julie Jensen the day before and previous visits which suggested major depression. I mean, we can look to the September visit where being tired, fatigue was noted. I want to talk about Julie Jensen's perceptions of reality. And I want to consider the wildly inconsistent statements of her. To Therese DeFazio, Mark wouldn't let her get a job. He was controlling. To the Voights, Mark is pushing her to get a job, and she doesn't want to. To Ann Lynch, she has to get a job because her marriage is in the toilet. To Laura Shore, she was actually offered a job and had a start date when she hadn't been offered a job and didn't have a start date. To Therese DeFazio, Mark always turned off the computer or covered it quickly. To the Voights, she'd walk past the computer screen and see poison on the screen. Mark would leave for work, and on the computer screen was a website for poison. I mean, I want to go through all of these, but on that one, right, like we heard about dial-up internet, and we heard about when these searches were. And so was the computer just logged on onto this website for 9-10 hours? To Ann Lynch, she said nothing about the computer. To Therese DeFazio, she wanted to put Douglas in all-day school, which is a special program for normal kids to mentor kids with special needs. To the Voights, Mark is making her put Douglas in daycare and she doesn't want to. To Ann Lynch, she was upset and crying about needing to put Douglas in daycare full-time and wanted to know if they had space. all of these statements are basically contemporaneous with each other. That Post-it note that we keep hearing about, where did it go? Julie was the one that took a picture of it. In the moment, the people that she showed it to, the people that knew Julie Jensen, who knew the context, who knew what her complaints and concerns were, they looked at that Post-it note, and how did they react? They thought it meant nothing. Think about some of Ted Voigt's testimony in this case. Evidently, he thought that Mark Jensen had killed Julie Jensen. And then when he was asked to describe that office, he didn't recognize it. I don't know if you remember this from the video. He didn't recognize it because when he had been in that office, later, things had been moved around. He was in that office after Julie Jensen had died, sitting there with Mark while Mark was helping him with stocks. So this neighbor who thinks that Mark Jensen was out to get Julie Jensen is then over there getting stock trading help from Mark Jensen in that office. You know, the thing about that, leaving the computer on so that when Julie would be vacuuming or walk by and she would see what was on and the door would be 3/4 closed. We saw a picture of that room. And we talked about this, I think it was when Detective Ratzberg was testifying about the scene photos. And we saw a picture of that room and the location of the computer and where the door was and how the door closed. And if that door was 3/4 closed, no one would be able to see the computer screen. That list, that Post-it note, that's such a big deal. It says DeFazio, Terry on it. Well, how does that play? How does Therese DeFazio play into this scheme of Mark Jensen's? It said Nicotrol. Didn't the state say that was prescribed to Mark? Is this like all the other lists that got talked about, and what does this mean? What do these letters mean? And then we learned from Dave Naring that they were stock symbols. And here we are, 25 years later, trying to assign meaning to these little nuggets of information when we know the meaning of these nuggets of information because the people who lived in that moment and knew her the best looked at it, and we know how they reacted to it. I want to talk about the offers of help that Julie Jensen received and declined. Ted Voigt offered to give Julie money and she could use his cabin, and Julie declined the offer. Therese DeFazio offered to set up Julie with a women's shelter. Julie declined and said her neighbor was working on getting her a place. But when that happened, she had already declined Ted Voigt's offer. Laura Koster offered to give Julie a place to stay with the boys and not allow Mark at the residence if Julie was actually concerned. She also said, your brother lives a couple of miles away. Take the checkbook and the boys and leave. Julie didn't call her brother. She didn't leave with the boys. She didn't take the money. She had her own car. Officer Kosman said, if this is real, go to the shelter if your life is in danger. She declined. You know, the state's wrong. We aren't suggesting that Julie Jensen was framing Mark Jensen with these statements about fear. These were paranoid misperceptions of reality. One of the things that Dr. West explained to us yesterday is she said that a person at high risk of suicide creates space for themselves to be able to follow through. She said she sees that in suicide cases. Julie Jensen created that space for herself. Her conversation with her best friend Laura Koster on November 30th. You're not going to see me for a few days. On December 2nd, she wrote the note to Therese DeFazio that she wouldn't be seeing her. Her conversation with Margaret Voigt on December 2nd. You won't be seeing me, don't worry, I'm fine. I want to take a look at the last 2 weeks of her December calendar. Well, actually, yeah, if you go back, these are some calendar pages in November. And they're full of things. And then when we go to some pages in December, there's nothing. Julie Jensen was aware of what she was doing. She was creating space for herself, like Dr. West described. Now the science, we didn't learn about the science and how ethylene glycol poisoning works from the prosecution. We learned that from Dr. Hale. And the blood levels tell us nothing about whether something is a homicide or a suicide. Dr. Mainland thought it's a homicide because it's hard to get someone to drink a fatal dose, and so it would have to be multiple lower doses. But then we learned that this little NyQuil shot was all that would be needed for it to be a fatal dose. And then there's nothing in Julie Jensen's toxicology that suggests this was anything more than a single fatal dose on the night of December 1st to the early morning of December 2nd. Now, the person educated in pharmacology who Laura Koster went to with questions about medicine, she didn't need Mark to explain side effects of Paxil or paroxetine. We learned about a person's mental faculties and their abilities while processing ethylene glycol. We learned about what Julie Jensen, the person educated in pharmacology, informed her neighbor on December 2nd that she was fine, it was her new meds, and Mark was going to the doctor for her. She knew that Mark Jensen was going to Dr. Borman's for her. Now that doesn't really fit with this idea that he's got this scheme and he's involuntarily administering medications and she doesn't know what they're for, and he's forcing her to take these things and he's drugging her against her will. We learned about the high likelihood that the half a teaspoon remnant of ethylene glycol in her stomach was just that, a remnant of a prior dose. We also heard from Dr. Mainland's extraordinarily questionable study. But the blood levels tell you nothing. But you know what was interesting about her study? Is that almost every ethylene glycol case that she could find was a suicide. That's sad, and it's what happened here. Mark Jensen did not kill his wife. We know this from the science. We know this from what Julie Jensen told her physician. We know this from when Julie Jensen said goodbye to Laura Koster. We know this from the description of David Jensen and how distraught and grief-stricken his dad was. Now, the prosecution has one more chance to get up for an argument. They'll have their rebuttal argument. I'm not going to have a chance to answer that. So this will be the last you hear from me in this case. Please think about the questions we've asked of the witnesses in this case. Please think about what my answer would be to the state's argument. This case is tragic on so many levels. There's depression, there's suicide, and there's an innocent man on trial for homicide. Mark Jensen is innocent, and we ask you to return a verdict of not guilty.
All right, ladies and gentlemen, we still have the rebuttal, but take your lunch break. How about 1:45? Is that good? All right. Please don't talk about the case. We'll see you back at 1:45.
Please rise for the jury. Thank you. Here comes the jury.
All right, we're back on the record on Mark D. Jensen, 2002 CF 314. The appearances are the same. It is January 31st, 2023 in the afternoon. The jury has numbers and are seated different, and I will tell you why we're doing that later, but there is a reason for that. So with that, the state has to do their rebuttal. Anytime you're ready, Ms. McNeil. Oh, I'm sorry. Anytime you're ready, Mr. Jambois.
Thank you, Honor. And thank you, ladies and gentlemen of the jury, for paying such careful attention to this trial. And here we are today, 24 years, 1 month, 28 days after Detective Paul Ratzberg was called to the scene of what the evidence shows was the homicide of Julie Jensen. Now, last night in preparation for what I knew was going to be my rebuttal, I watched the opening statements. I watched them on YouTube of the opening statement by Carly McNeil and the opening statement by Mackenzie Renner. And then I just watched the closing argument by Mackenzie Renner and the closing argument by Jeremy Perry. And I was struck by this point in Mr. Perry's closing argument where he said, he didn't want you to be responding to emotional appeals that cloud the evidence. I wrote it down, just to make sure I got it right. And I'm wondering, what could he be talking about? I mean, I watched Mackenzie Renner's opening statement, and I just watched her closing argument, and it was not an emotional appeal to cloud the evidence. If anything, it was a very clear-cut, detailed, and I'd say somewhat dispassionate recitation of what the evidence was going to show in her opening statement and what it did show in her closing argument. And I was struck by the extraordinary similarity between her opening statement and her closing argument. In fact, I would say they were identical. And there's a reason for that. It's because in between the two was the evidence that was presented to all of you, and it was presented to you in exactly the way that Carly McNeil told you it would be presented to you, and it was presented to you in exactly the way she said it was presented to you in her closing argument. So if we're talking about emotional appeals, let's see, emotional appeals that cloud the evidence, the first thing that came to my mind was the defense opening statement. In fact, the opening lines by Mackenzie Renner, where she spoke of, and I can't quite emulate the tone of voice that she used, but it was like a broken tone of voice, like a distraught mess of a man, eyes red from crying, snot bubbling up from his grief, had trouble standing up. Well, I guess that was an emotional appeal, but it didn't cloud the evidence. It was just pure fiction, because you never heard any evidence like that, did you? I know you didn't. I was sitting here in the courtroom with you. There was no evidence of anything like that. In fact, they asked Dave, I forgot Dave's last name, but the paramedic who responded, who's now an assistant chief, and they asked him, well, do you know anything about defendant Mark Jensen? No, I just was going there to take care of the victim. And so he described to you the scene, the victim, her condition. There was no evidence at all of this, the opening couple of paragraphs in the defense opening statement. And there were other things in the defense opening statement that simply were never, there was no evidence presented to you. When they had the opportunity to present their evidence to you, they didn't present any evidence of any other person besides Mark Jensen and at one point Laura Koster, speaking of Julie being suicidal. DeFazio said she was not suicidal. Dr. Borman said she was did not appear suicidal. She was distraught. She was upset. There was no testimony from any witness here that Julie Jensen, that any other third-party lay witness had ever heard Julie Jensen talking about suicide. That was mentioned in their opening statement, but when they had the opportunity to prove that to you, to present evidence of that, they didn't, did they? And then they also, during the course of their part of the case, if there's something important that they want you to know, that's when they're supposed to bring it out. Now, in his closing argument, Mr. Renner referred to this as being, I'm sorry, Mr. Perry, not Mr. Renner. Mr. Perry referred to this home computer as the second home computer. Where did that come from? Another thing that was just made up out of whole cloth. They asked David Jensen, wasn't this the second home computer? He said, no, not that he remembered. There was simply no evidence of this being the second home computer. And remember, there was testimony about how common it was to have a home computer in a residence in 1998. It was very, very, very unusual. In fact, Detective Ratsberg said this is the first time they'd ever seized a computer from a residence in the course of an investigation. So the emotional appeal, I don't know, maybe he was thinking I was going to do it. Maybe he was talking about my cross-examination of these hired guns that the defense brought in. The $23,815 testimony from Dr. Lindsay Thomas. The $10,000 to $15,000 testimony from Dr. Stacy Hale. And, I don't know, the $10,000 plus testimony from Dr. West. Because I did cross-examine those witnesses, and perhaps that's when he was talking about emotional. But, you know, that was very directly connected to the evidence. Now, defense counsel also, in his closing argument, told you some things that the evidence just didn't support that proposition. Remember when he was talking to you about how the evidence showed that Mark Jensen could not possibly have been on the computer on December 2nd at 11:45 or 11:43 a.m.? And I'll ask Ms. McNeil if she could pull that up. Not his argument. We're not pulling up Mr. Perry's argument. We're pulling up the evidence about the use of the computer on December 2nd. And that evidence, when you see it come up, is going to show that the internet was used on the Jensen home computer at something in the neighborhood of 11:45 a.m. on November 2nd. He said, well, that's not possible. It's not possible that he could have been using the computer 11:45 a.m. or at whatever time it was because, he was picking up the prescription. Well, the evidence also showed when he picked up the prescription, and it was at 11:13 a.m. So first of all, here's the internet usage, and you can see 8:14 a.m. to 8:49 a.m. Well, he was saying, at 8:14 a.m. to 8:49 a.m., he was taking Douglas to preschool. Well, that's not true. There's no evidence that he was taking Douglas to preschool at 8:14 to 8:49 a.m., and in fact, we know for a fact that he wasn't. You want to know how? We know that he was not taking Douglas to preschool at 8:14 to 8:49 a.m. because there he is on the computer at 8:14 to 8:49 a.m. And there's no evidence that Douglas was being transported to daycare at 8:14 to 8:49 a.m. other than what Mr. Perry said to you in his closing argument, and that's not evidence. Opening statements and closing arguments are not evidence, and I guess there's a good reason for that when you consider the opening statement by Mackenzie Renner when she's talking about the defendant's distraught condition on the morning or in the afternoon when law enforcement responded to the scene of Julie Jensen's murder. And then we can bring up, do you have the receipt or the record of the pickup of Ambien? It was 11:13 to 11:14 a.m. While she's looking for it, I can just tell you that's what it was, 11:13 to 11:14 a.m. Because I know the evidence in this case. Because it wasn't just Detective Ratsberg that responded on December 3rd, 1998. 24 years, 1 month, and 28 days ago. I was there too. You know, in his closing argument, Mr. Perry spent a good 40 to 50 minutes talking about Aaron Dillard and Ed Klug and talking about their credibility or his perception of their lack of credibility. But remember, when did they come into this case? In 2007. In 2007 is when Ed Klug and Aaron Dillard first came into this case. There's no indication the state had ever heard of either one of them before 2007. Yet when was this case issued? In March of 2002. So do you actually think the entire state's case hinges upon the testimony of two people we'd never heard of, never seen? Obviously not. What do you suppose the evidence in this case actually does hinge upon? It hinges upon all this evidence that the defense counsel wants you to ignore. Now, there's been an unusual amount of discussion about penises, considering that this is a homicide case. But do you honestly think that we were talking about penises as a means by which to misdirect your attention away from the evil, unspeakably awful things that this man did to Julie Jensen? Do you really think that's the thing we wanted you to focus on? No. The reason that we talked about these penis photos and the astonishing collection and array of penis pictures on Mark Jensen's work computer that was recovered in 2002, it's not because we want to show you that he's got a strange and sick obsession with penises. It's because we wanted to show you that his strange and sick obsession with penises drove his behavior in the years of harassment of Julie Jensen. Now, think about what the defense theory of the case is here. That Perry Tarica, a man whom you saw testify in this case, and a man who clearly loved Julie Jensen and described her to you as the finest, kindest woman he'd ever met. Now, did you get the impression that Perry Tarica's testimony was contrived? Or did you get the impression that Perry Tarica was telling you the God's honest truth about this woman that he loved? Do you honestly think as you're sitting here right now, that any normally constituted human being, any normally constituted man, for 7 years after his girlfriend breaks up with him, for 7 years, he does hang-up call after hang-up call after hang-up call after hang-up call. For 7 years, he drops explicit pornographic photos off at the residence of Julie Jensen and at the office of Mark Jensen. Do you honestly believe that? That doesn't make any sense, does it? On the other hand, if you're dealing with a sadistic, narcissistic sociopath, which the evidence shows Mark Jensen is, then it makes perfect sense. Because you see, doing all these hang-up calls, the person who's doing it doesn't see the result. Dropping off these photos, the person that's receiving the person that's, Perry Tariq would not have seen the effect that it's having on Julie Jensen. The police saw it. The police saw how distraught and humiliated and embarrassed Julie Jensen was by this. And Mark Jensen saw it too. And Mark Jensen, when he'd get, as he put it, one of his few truthful statements to Detective Ratzberg, I mean, he told the truth in some instances to Detective Ratzberg. It was, as defense counsel referred to it, Mr. Perry referred to it in his closing argument. I wrote it down so I get it right. Blends facts with fiction. So who is blending facts with fiction? You know, part of this case, when you're looking at the way people were speaking about the case, and the way Mark Jensen was speaking about the case, you've got to look at the process in which this case unfolded. So when Mark Jensen was talking to Paul Ratzberg on April 21st, 1999, he'd never heard of Ed Klug. I mean, well, he'd heard of Ed Klug. He didn't know that we knew what Ed Klug was going to tell us. He didn't know that Ed Klug was going to come forward and tell the truth about that conversation on November 7th, 1998. So on April 21st, 1999, what Paul Ratzberg knew was pretty much only what Paul Ratzberg told him. Of course, in addition to what he did. So on April 21st, 1999, Mark Jensen knew how he killed Julie Jensen. And then he found out from Paul Ratzberg what we knew about how Julie Jensen died. So he was blending fact with fiction. He had to disclose what he knew that we were going to find out. David was there with him. So he had to disclose that David said, well, yeah, she couldn't get out of bed, or David said she couldn't talk. She could not talk that on the morning of December 3rd. So Mark Jensen was telling the truth about Julie Jensen's condition on the morning of December 3rd because he had to. He had to, because David was there with him. So he had to tell that much of the truth. And he did not know that we were going to later prove that at 9:42 a.m., somebody was on the computer looking up looking up ethylene glycol, and why isn't she dead yet? You know, what are the stages of ethylene glycol poisoning? He didn't know when he was talking to Paul Ratzberg on April 21st, 1999, that was information that Paul Ratzberg had already. And Paul Ratzberg didn't tell him that. So he told the truth. That on April 3rd, 1999, on December 3rd, 1998, on that morning, Julie couldn't get out of bed. He said it multiple times. Could you pull that up, Ms. McNeil? Answer, she couldn't get out of bed that morning. Answer, I mean, I'd hate to have it come to that, but you can ask David about Mom's condition that morning. She couldn't get out of bed. He wanted to stay home because Mom was sick. We did nothing, you know. There was no sexual thing going on that morning. And then later, well, she had to get up, get water. Answer, I brought it to her. Question, Answer, she did not get out of bed. Question, so you did have some conversation. She asked you to get a glass of water. Answer, no. I got it for her. She had nothing to say. David, after that fact, I think she was giving me indications like nodding her head or something like that. But David said that she couldn't talk that morning. So you see, on April 21st, 1999, he was blending fact with fiction. So when he was confronted about Kelly Labonte, no, oh yeah, well, she's just, she's the secretary for Scott McQuay. Girlfriend, no, she's not my girlfriend. And then when he starts showing the emails, you mean that, Kelly? Oh, yes, well, then yes. Okay, now, yes, now, on April 21st, 1999, now, yes, you could say that. But even, it was very difficult to get a straight answer out of this guy who was blending fact with fiction. And do you think it's because he was too stupid to understand the question, or do you think he was smart enough not to answer it? Blending fact with fiction is Mark Jensen's pièce de résistance. It's his calling in life, to mix fact with fiction. So take the fact of Julie Jensen's one weekend affair with Perry Tarica in 1991, and then build the fiction around it, that Perry Tarica is doing all these hang-up phone calls, but that's not enough. Eventually, he's got to make it better. He's got to make it more humiliating, because he's a sadist. He's sadistic. The evidence shows that he's sadistic. And what means did he have by which to perpetuate this sadistic plan that he had? Well, he had a seemingly endless array of penis photos on his computer, and a seemingly endless array of fellatio pictures on his computer. He had an endless stock of pornography that he could use to humiliate and demean Julie Jensen with for years and years and years. And that's the mark of a sadist, a controlling, manipulative sadist. And then you have Turtle. It looked like an email from Turtle to Julie Jensen. That's the email that he showed her with these disgusting, revolting photos. And by the way, talk about somebody being bought and paid for. Consider the testimony of Dr. West. She wouldn't even acknowledge that, this 36-page record of harassment that was maintained by Julie Jensen at the request of a law enforcement officer, Dr. West could not even bring herself to acknowledge that that's a form of harassment or that's evidence of harassment. Couldn't even bring herself to acknowledge that Turtle to Julie email with those disgusting, revolting photos on it, she couldn't even bring herself then to agree that was harassment. So maybe I got a little bit upset with Dr. West, because I think when people get on the witness stand, they're supposed to tell the truth, no matter how much they're paid to disguise it. So Dr. West, with her lofty degrees and her forensic psychiatry specialization, and Siggy caps, and you remember Dr. Hale laughed at me when I said Sige caps. Well, I apologize to you, ladies and gentlemen. I mispronounced Siggy caps. But I knew what the first letter of Siggy caps was. It's an S. And what does it stand for? It stands for sleep. The very first thing, the Siggy caps, the very first thing for analyzing depression with a patient is to talk about sleep disorders. And don't you think that Dr. Borman, a board-certified family practitioner with years and years of experience And he said, many patients who came to him with depression. Don't you, in fact, he talked about Siggy caps. So don't you think he talked about sleep? He did. He said he did. And he said he made no notes of any kind of sleep abnormality or sleep problems with Julie on either September 21st or on December 1st. And you don't have to take my word for it. You can look at his notes. Of course, good luck reading them, but you can consider his testimony. He never said anything about any sleep disorder. And yet, what did Dr. West say about Siggy caps? Oh, yes, Julie Jensen had a sleep problem. Well, where did that come from? Well, Dr. Borman's notes. Well, that was Dr. Borman's notes from December 2nd when he was talking to Mark Jensen. So it was Mark Jensen was the origin of her sleep disorder, not Julie Jensen, not Dr. Borman. It all came from Mark Jensen. But she just could not acknowledge, well, no, that came from Mark Jensen. No, she just couldn't say that. No, it was in Dr. Borman's notes, therefore it came from Dr. Borman, even though the evidence is absolutely, positively, unequivocally clear that all of that information about sleep problems came from Mark Jensen. And when did it come from Mark Jensen? Years and years and years after he'd been charged with this offense, because she interviewed Mark Jensen for 5 hours. And the other guy, Dr. Herzl Spiro, whom you didn't hear for, but she read his report, he'd interviewed him for 14 hours. Now, what do they teach in these psychiatry courses where you can become, where you get board certified as a forensic psychiatrist when you completely ignore the evidence? When you consider the prime suspect in a first-degree murder, that's the best source of information, most reliable source of information you're going to get about the condition of the victim in the months preceding her death? It's Mark Jensen and Laura Koster. And you saw Laura Koster. You heard Laura Koster testify. And you heard the testimony about what Laura Koster had truly actually said to Julie Jensen about a week and a half before she died. Because you heard Ted Voigt testify about it, and you heard Teresa Fazio testify about it. And what did Ted Voigt say? Ted Voigt indicated that Julie told him that Laura had told Julie, I lived with him after Julie had shown him this Post-it note, Laura Koster told Julie, I lived with him for 18 years. You have no idea what he's capable of. Now, Laura Koster denies making that statement, but she didn't deny living with him for 18 years. So what had the ring of truth to it? And then Laura Koster denies calling Paul Ratzberg crying and upset sometime around December 4th or December 5th saying, I think my brother killed my best friend. Well, how many brothers did Laura Koster have? And how many best friends did she have? So didn't Detective Ratzberg's testimony have the ring of truth? You know, there's so many little things about this case. There are so many little things. Take Dave Nearing. Dave Nearing testified that Mark was complaining to him about how he wanted his computer back, his home computer back. And this is on a Friday afternoon. And Dave Nearing said, well, you know, you should be happy they didn't take your work computer. And what happened the following Monday? Do you remember what happened the following Monday? Dave Nearing comes to work, and Mark Jensen approaches him and says, oh, my computer's fried. I have to get a new computer. Now, at some years earlier, Dave Nearing also recounted a conversation when Mark Jensen indicated that you could fry a hard drive on a computer by putting a magnet over it. Now, defense counsel made much of that. You know, they were cross-examining Jason Ruffle. You can't destroy a computer that way, can you? And it would take a 4,500-pound computer or something. Yeah, well, it's not like we said that you can destroy a hard drive that way. Mark Jensen said it, so he was wrong. That's what he said. Because Dave Nearing has no motive to lie to you. Dave Nearing had no motive to lie to you about the time on December 3rd, 1998, when Mark Jensen said he was at work, and Dave Nearing said he wasn't, and Meredith Perez said he wasn't. The people that were at work who testified in this case on December 3rd said Mark Jensen was not there. I think Rose McGinnis said that too. Everybody that testified who was at work on December 3rd, 1998, in the Racine office of Stifel Nicholas said Mark Jensen was not there, which is a rather inconvenient fact since that's Mark Jensen's alibi for about the time that Julie Jensen was murdered on December 3rd, 1998. In the closing argument, defense counsel made much of saying Julie used the internet. Well, of course, here's the problem with that assertion. There is not one whit of evidence in this case that Julie ever used the internet. Not one whit. In their opening statement, they said, well, there was internet usage on this date when Mark was at work and Julie was at home. Well, remember Jason Ruff testified about that. No, that actually wasn't internet usage. That was the computer updating itself. There's certain things that update themselves. He said it was something that would take 1 to 2 seconds, and the computer would do that itself. There was simply no evidence that this computer was used when Julie Jensen was home alone. When Mark Jensen was off to his blueprint on November 5th, 6th, and 7th, the computer was not used at all. Now, defense counsel said Julie never told anybody about being sick the weekend that Mark was away at the Blueprint conference. Well, again, sometimes you hear these closing arguments from defense counsel, you wonder if they've been sitting in the same courtroom. Now, acknowledge it's a long trial, but you all saw and heard Ted Voigt's videotape testimony, where Ted Voigt specifically, unequivocally indicated that 2 to 3 weeks before Julie died, she told him that she'd gotten sick. And so she was afraid that Mark was trying to poison her. So she was afraid to eat or drink anything around the house. I'm not making that up. You saw it yourself. You saw it on the screen. Some of you looked at that screen, some of you looked at that screen, but you all saw and heard Ted Voigt testify about Julie being sick 2 or 3 weeks before she died, and how she was afraid to eat or drink anything because she was afraid that Mark was trying to poison her. And by the way, might that explain some weight loss? If you're afraid to eat or drink anything around the house because you're afraid your husband's trying to poison you? There were no searches on the internet for divorce. Well, there are a couple of reasons for that. Number one, Julie didn't use the internet. Number two, she already had a divorce attorney. Remember, she'd filed for divorce in 1990 or 91. I think it was 91. So she already knew who her divorce attorney was going to be. She didn't need to look it up, even if she could, and there's no evidence that she could. But the guy who wanted to run off with his girlfriend on the Windstar cruise, the guy who was having sexual relations with Kelly Labonte, or Kelly Greenman, and then, I think during most of this relationship, when it started in September, she was Kelly Labonte. When it continued by October 1st, she'd just gotten back from her honeymoon, and it started up again. By that time, she was Kelly Greenman. He was having sex with her again. Going off again in the end of October to meet her in Chicago for 4 days. Then she was Kelly Greenman. There was no evidence that Julie Jensen used the internet. And here's the other thing about Julie using the internet. If Julie used the internet, don't you think he'd know about it? If Julie used the computer, don't you think he'd know about it? And if Julie used the computer and he knew about it, do you honestly think he'd have internet exchanges between him and his girlfriend? let's run off somewhere. Let's do a Windstar cruise. I do love you. I miss you. I want you. Do you think that would be on his home computer if Julie used the computer? Now, defense counsel also said in his closing argument, well, no, we're not saying that Julie was framing Mark for murder while committing suicide. We're just saying she committed suicide. Well, the problem with her just committing suicide is that the evidence is plainly and unequivocally contrary to that. Let's start with what Julie said. Julie was telling her next-door neighbor, her confidant, Ted Voigt. She was telling her third-grade teacher, and she was telling her best friend, Laura Koster, that she was concerned that Mark was trying to kill her, or was trying to poison her, or he was trying to make it look like he was doing that so she'd do something that would make her look crazy. That's what she confided to Ted Voigt. That's what she confided to Laura Koster. That's what she confided to Teresa Fazio. Isn't that kind of inconsistent with a suicide? Now, of course, Dr. West explains everything away because, she had a distorted perception of reality. Well, Dr. West, how do you know she had a distorted perception of reality? Well, because she thought her husband was trying to kill her. Well, doctor, what if he was trying to kill her? Or what if she had reason to believe he was trying to kill her? Well, that was because of her distorted perception of reality. You see the circular reasoning there? Maybe you could see how I was starting to get upset with Dr. West and the nonsense and the BS that she was trying to feed you. So she was looking at the Siggy Caps thing, and there was this major depressive disorder, and the first S in Siggy Caps is for sleep, and the only evidence of sleep disorder comes from Mark Jensen years after Julie's been murdered. Oh, and then what about I? What was the I in Siggy Caps? Anybody remember? It was interest. Julie lost interest. According to Dr. West, who was paid to review this case. Remember, she was paid to do this. She was paid a lot of money to do this. A lot of money. And what did she see about interest? Yeah, well, there was no evidence one way or the other about that. Well, except, of course, you know that's not true. Because you heard testimony from Marion Passetti. You saw her on the television screen. She testified at the last hearing. Remember, she said that Julie called her on November 30th. Julie called Marion Passetti. And what did she call her about? Something about which Julie had a profound level of interest. Gardening. Julie wanted to know what Marion Passetti's information, what Marion Passetti could tell her about how Marion Passetti had such a beautiful garden early in the spring. And so Marion Passetti was telling her all about how you get these seeds in the early winter, and then you get potting soil, and you set it up in your basement, and you get sun lamps, or these black lamps that provide sunlight, and you start your garden in the basement. So Julie was asking Marion Passetti very detailed questions about this. Marion Passetti said that conversation lasted 20 minutes to a half hour on November 30th, 1998, the day before Julie went to see Dr. Borman. So the day before Julie went to see Dr. Mormon, and 4 days before she was dead, Julie Jensen was talking with her friend, her neighbor, about having a detailed conversation about setting up her winter garden so that she could have early spring garden. But Dr. West didn't see anything significant. She didn't know about that, apparently. And if she had, well, of course, Dr. West could explain away anything that was inconsistent with suicidal intent, because under suicidality, she had admitted there was no evidence of suicidality. She admitted that. Julie never told anybody she was going to commit suicide. Julie had never attempted suicide. Julie had never made any plan for suicide. Any plan for her two boys that were everything to her. Her plan, apparently the defense theory is that Julie's plan was she'd leave the children in the care of the man who she believed was trying to kill her or make her look crazy? Julie had no suicide plan. She had never attempted suicide. She never talked about suicide to anybody at all. Mark Jensen also talked to Paul Griffin. And again, remember, we're talking about blending fact with fiction? Well, I shouldn't say we're talking about. Mr. Perry talked about blending fact with fiction. And if you look at the lead up to the point where Mark Jensen was charged with first-degree murder, that's what he was doing with everybody he talked to outside the family. When he was talking with Paul Griffin on February 24, 2000, this is Mark said about December 2nd. Right. The night before, the night before was when I think, if I remember it, it was the night we had macaroni and cheese, and we made that, and I botched that real good, and she wasn't even awake much. I mean, she was in bed the whole time. She was sleeping most of the time. I think the kids were being quiet not to wake her. I mean, there was some conversation that night, but she was pretty much out of it. That was Mark Jensen's description to Paul Griffin of Julie Jensen on about her condition on December 2nd. And he said that on February 24th, 2000. And then what did Mark Jensen say in his blending fact with fiction about December 3rd? He told Ratsburg, David stated he observed his mother breathing very heavily and had labored breathing the morning before her death. David stated he told several friends about this as well. David asked his dad the morning of December 3rd if his mother needed to go to the hospital. His dad said no. However, if she was worse later in the day, they would take her to the hospital. David said it was too late as they returned home and they found her dead. David said his mother was not eating, however, she was drinking a lot of water. And then the defendant's interview, page 71. She couldn't get out of bed that morning. You can ask David. She couldn't get out of bed. He wanted to stay home because Mom was sick. She was in bed asleep. And then page 82. There was a question between myself and the kids that morning whether or not to call an ambulance, take her to the hospital, and the kids wanted to stay home. Her breathing was funny. She could hardly get out of bed. I mean, it was a god-awful situation. The bruising probably came from her getting up. I didn't hit her. She got up and she fell. She hit her head. I remember her telling me that. She got up to go to the John. And then at page 89, from 6:30 in the morning, she was not able to get out of bed. I mean, she was groggy, almost incoherent. Breathing was very labored, raspy. David tells me we talked about it. David tells me that I was holding her up, supporting her. Page 119. He had to bring her water. She couldn't even go to the John. David said she couldn't talk that morning. Page 138. She didn't get out of bed. She had a hard time breathing and could barely move on her own from 6:30 on. Blending fact with fiction, the fact that Mark Jensen knew he had to disclose because David was right there with him for this April 29th interview. And then the phone call that Mark Jensen had with Paul Griffin on January 9th, 2000. Mark, I didn't even hear her talk Thursday. How to describe it, to have it make sense to you. Her breathing was labored, kind of wheezy. She was cognizant of what you were telling her. She was weak by Thursday. I doubt she could have, if she could have got out of bed, it would have been crawling. Blending fact with fiction on April 21st, 1999, before Mark Jensen knew that we had computer evidence that we recovered from his computer, establishing that at 9:42 a.m. on December 3rd, 1998, somebody was looking up the late stages of ethylene glycol poisoning, unconsciousness, loss of consciousness, so forth. How to explain that? How to explain that when she couldn't get out of bed? Well, there is no explanation for it. That's consistent with the defendant's innocence. The only explanation for that is Mark Jensen was continually upset that Julie wasn't dying quickly enough. Here he gave her this antifreeze on the evening of December 1st. He was hoping she'd be dead by the morning of December 2nd, and there she was still alive. And he woke her up, and he was saying, or she woke him up, and she was dizzy and drunk. She ended up feeling drunk, and she needed an explanation for that. So he needed something to cause her to sleep through the poisoning. And so he went to see the doctor on December 2nd. And Julie thought, we know this because Julie talked to Margaret Voigt. Julie called her friend Margaret Voigt on the morning of December 2nd, and Julie was happier than she'd been in weeks or months. Here she was desperately sick, desperately ill, very uncomfortable, very, very uncomfortable. But she was happy because Mark was taking care of her. Mark was being good to her. Mark got the boys off to school. Julie was finally getting what she'd been looking for. She was getting a supportive spouse instead of the sadistic, narcissistic thug that she was actually married to. She thought Mark loved her. And when Mark got back from the doctor, he showed again how much he loved her by giving her the Ambien pill that the doctor had prescribed for her, and giving her another half a dose of paroxetine, and, helping her wash it down with orange juice and antifreeze. What a loving husband. Didn't she have reason to be happy on December 2nd, 1998 at 10 a.m.? She'd been lulled into believing that this monster that she was married to was finally showing her a little bit of love. That's what the evidence showed in this case, ladies and gentlemen. And you know he's guilty. Thank you.
Now, members of the jury, the duties of counsel in the court have been performed. The case has been argued by counsel. The court has instructed you regarding the rules of law which should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, conscientious decision of this case is to be thrown wholly upon you, the jurors, selected for this important duty. You will not be swayed by sympathy, prejudice, or passion. You'll be very careful and deliberate in weighing the evidence. I charge you to keep your duty steadfastly in mind as upright citizens to render a just and true verdict. The verdict submitted. The following two forms of verdict will be submitted to you for your consideration concerning the charges against the defendant, Mark D. Jensen. One reading. We, the jury, find the defendant, Mark D. Jensen, guilty of intentional homicide of the first degree as charged in the information. The other reading, the jury, find the defendant, Mark D. Jensen, not guilty. It is for you to determine which one of the forms of verdict submitted you will bring in as your verdict. This is a criminal, not a civil case. Therefore, before the jury may return a verdict which may legally be received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other juror. If you need to communicate with the court while you are deliberating, send a note through the bailiff, signed by the presiding juror. To have a complete record of this trial, it's important you communicate with the court only by a written note. If you have questions, the court will talk with the attorneys before answering, so it may take some time. You should continue your deliberations while you wait for an answer. The court will answer any questions in writing or orally here in open court. When you have agreed upon your verdict, have it signed and dated by the person you have selected to preside. After you have reached a verdict, the presiding juror will notify the bailiff that a verdict has been reached. Everyone will return to the courtroom. The verdict will be read into the record in open court. The court may ask each of you if you agree with the verdict. At this time, we'll swear in the bailiffs if they all could come in front of the clerk.
Do you swear that you will, to your utmost of your ability, keep all the jurors sworn on this trial together in some private and convenient place, subject to the direction of the court, until agreed on the verdict or discharged by the court, and that you will not, before they render their verdict, communicate to any person the state of the deliberations or the verdict they have agreed upon, so help you God?
I do.
Thank you.
All right, the record should reflect the bailiffs were sworn in. All right, I have one more duty before we can start the deliberations, and it's a difficult one because all 16 of you have shown up on time. We're in the fourth week. It's not been easy. Sometimes the weather wasn't pleasant. I gave you short lunches. We had a lot of videos to watch. So it's difficult for me to say this. 4 of you cannot deliberate. And it's all random. You all have your numbers. We're just going to use the numbers. The other thing I have to tell you, the 4 that cannot deliberate, you are not excused yet. Because there could be an issue in the future, and it's a legal issue. I don't want to get into it now. We might have to consider you for something. So the 12 that are picked will deliberate in the back. The other 4 will be in another room, and we will tell you where you have to go. So let's do the random picking by numbers. What number?
Number 3.
3. You don't have to stand up, but you know number 3.
Number 4.
Number 4.
Number 6.
6. One more.
Number 5.
Number 5. Okay, have all 16 walk out in the back all together, please. Joe. Of the courtroom. If we have questions, my policy is to bring all of the lawyers back and the defendant. So you cannot be far from the courthouse, but you have to leave a number with the clerk so we can call you. And I usually make a copy of the question for both lawyers, and they can review it before we decide what to do.
Your Honor, I have one question, and that is with respect to the 4 alternates who are they weren't given any instructions as to what they could do aside from staying in that one room.
They're not going to do anything.
Well, but did you tell them they're not going to deliberate among the 4 of them?
We're going to have a bailiff with them in that room.
Oh, I just want to,
We're not going to have 2 verdicts.
I understand that, Your Honor. What I wanted to make sure of is this. I mean, I don't know what the defense is going to do in this unlikely event that we're going to need to get one of those jurors. And so I want the record to be clear that the 4 alternates are going to be instructed to stay in a room and they can talk about anything they want except they can't talk about the case.
We will tell them that.
Thank you. Is that
Have my word
defense
on
counsel
that.
agree with that?
Any objection? No. Yeah. And I'm not going to give them their phones either, so they're not going to be able to surf anything.
Okay. Cruel and unusual punishment.
I will
Judge.
do it.
I like the little pet things like
Okay, but make sure you give the phone number to the clerk. Okay?
Okay.
Thank you.